Have you filed any application for that? Lordship. Along with medical documents? Lordship. Give it. Now I filed a copy. Wife is not well tomorrow. Lordship. Tomorrow. Because I know for vacation time.
Office is only it.
And if it is not registered, it will not be taken up. Lordship. It is driving number only. It is not registered. So therefore you then put it day after. Day after. You get it number so that day after you verify. Day after. Okay. Yes. Yes. Mention your yes.
Yes. Now I have challenged the order of cognizance, my lord. Page number 6. Against RPF officer, the Board of Security Force officer, my lord. He was not present. He was a Kashmir. He was a commandant, rank of additional commandant, my lord.
Sir, the clear appeal is a question of fact to be decided by the trial court.
They have not decided, my lord.
They will not decide. No, in cognizance says how plea available will be decided. It has to be tested from the trial.
Well, you will kindly see I given the certificate for granted by the.
Maybe I don't know. See, these things has to be looked into by the trial court only.
You will and page note 7 of the IMF.
Yes.
Page note 7 of my IA.
IA. Which IA? I remember.
I remember.
Yes, I got it. Page 7. Got it. It certified that.
He was in the Rastam Guru, my lord. Now, at present, today, my lord, he is in Kapri. There is not there. And ordinarily will not come without prior sanction of the government.
Sure.
How you will train in village volunteer?
Now, when the offense has taken place?
Operation is 19, my lord. In the year 19. India is 19. He has been appointed.
I am not able to follow. When the offense had taken place?
He has been appointed the army officer, my lord.
The officer can't come to Orissa.
No, my submission is that when they will come, they will get sanctioned. After all, they were sanctioned.
He might have come without permission also. How do I know?
Prior sanction cannot be married.
How do I know? He might have fled away.
That's a good.
He might have committed the crime and went away.
He might have also advised me to apply the technical to court. I will that category marriage. Because these facts are
Simply marriage.
just after
Simply marriage.
all right.
Attempt to
You don't have a case.
But
You don't have a case.
once matter dismissed. Again, this
I am not aware of the list.
Okay, it's all right. No problem. I'm just adjourning it. Yes.
attempt to
No, please. This is sure. Well, yes. Yes. So, the order confirming the court business order under Annex 2 and Annex 4 is under challenge. Yes. Well, the present petitioners are the father-in-law and mother-in-law of the opposite party respondent member. The opposite party respondent instituted a case under Section 12 of the PWDV Act. Notice was issued. Notice? No, notice was not issued. The notice is valid. Yes, notice has to go. Notice, issue notice, written notice. Only on the point of share household, I am challenging this. Let us see, letter come, we'll see. Stay for the question. Stay means it will come after 20 years. Hello? No, 20 years itself. So it can be disposed of. You move application. What is going on there? Hello? What is going on? No. But specific direction was issued. The husband who pay maintenance of rupees 6,000 per month. Yes, sir. But my lord, I am not saying to stay the maintenance, my lord. Their household, they are staying in the rented house. And the respondent wife, my lord, is forcefully staying with them. But then how say then? Throw it out. That I have told my lord, the operation of the order, sir, how can you throw her out without hearing? Issue notice on the application also. Please immediately after vacation. Immediately. So who's your SOD?
Then I can't throw her up. I don't know whether she stays or she doesn't stay.
I will find out.
Yes, then if something happens, then you will take your stay order and throw her out from the house. And it will be complicated. Yes.
Lordship,
Please on the application as well as the main petition, please immediately after.
little bit I will file by Wednesday.
Yes, but yeah.
Item 4,
Item 4 election, I will taken up after vacation. Why will you file it? Well, gap of Mishra in US and I will. Yes, filed the memo also. The council for the petitioner seeks to withdraw the petition. This is withdrawn.
item 5,
Customers. First, in this case, some challenge order of cognizance on primarily on two grounds, that the company has not been arrested as an accused, and secondly, if you looks at page 28, there is no affidavit to the complaint minutes. Covered by law.
What are the offenses?
There's 74 to 9 sack minutes.
Where is the complaint? Where is the complaint?
Okay. This minutes. First, you only wanted to check whether
No, what do you want to show? Let us see the complaints.
next page 28 of the complaint minutes.
Complaint.
Again, I'm sorry, but
It starts from
page 24 again.
24.
Again, I think they have added the directors, common directors of the company minutes. The company was subcontracted to sale minutes. Sale has also not been added as a key. It's a lessee. We were the contractors minutes, and we are at number 4 and 5. Page number 24, I'm at 4 and 5 also. The company was not added as an accused minutes.
You are 4 and 5.
Again. And minutes would kindly see page 28 also minutes. I'm sorry.
28. Yeah.
Again. There is no affidavit to the complaint minutes.
Yes, Mr. Ravana.
lots wanted to know last at the stage of the trial.
Trial minutes. Again. Chat frame ही नहीं गया ऑर्डर again. ऑर्डर को verbally what you had asked.
What is this then?
These are the two orders, my lord. There's similar cases had come up where the company was not made as an accused. In these two cases, this honorable court has set aside the order of cognizance on the ground the company was not made an
What are the offenses in this case?
Well, in one case, there is a case under the India Act, the other is under NI Act, 141. In both of them, under EPI Act and under
This is an NI Act.
NI Act, but
NI Act is something different.
in this case also, brother, under the EPI Act, it must not happen. But we relied upon the judgment matters.
Which one? Mine. What is an
I get.
Where is that order?
Orissa mining order. So
923 of 2018. Where is that one side?
Sultan had asked I would main base boxes sit at.
Show me something.
Second matter is এটা একটু একটা হতো না এটা সেলফ এটা গভর্নমেন্ট করতে এটা দেখতে পাচ্ছেন পরে কি এটা অর্ডার করতেন প্যারাগ্রাফ তার আগে লাস্ট প্যারাগ্রাফ হচ্ছে দেড় বছর খরচ করি না
Offenses.
offenses either 15 or 16 the environment
Environment protection. But you are the mining.
the second order that I refer to second I'm sure
Why would you insert? This is only one.
this is only if you take at it अपन पहले किस आरे तक टोटल कवर करते हैं
This one.
again
But you are throwing 138 environment and all. Where is the mining offense?
दो चाहिए
You show me the kind of mining offense. Directly number 2.
पूरा 86 पूरा 86
That's what you have given earlier. But
1724
you are not
para 1724 again
para 4.
again
17. Would you show me this? Para?
4 again
Yes, this is relevant.
again I'm sorry my apologies
All the judgment you have given.
my apologies
Like that.
again
The petitioner has the order dated. What is the order dated? 2.
again I'm sure
Order dated. Where is that order? Date.
I'm sure again
Date.
Date is 30th May 2000 minutes.
30th,
May 2000.
30th May 2000. 2000.
Again. That's a lordship. Ask me. Ask me. Trial.
Why are you waited for this such a long time?
The statement is there. I'm not teacher. Charge frame ही नहीं.
And then argue all this thing at the stage of charge. Because you came late. Argue all this point.
No, sir. Then the person will suffer the ignominy of it.
No, I already suffered. 2000 to 2002.
No, prosecution has
All this point.
the ignominy of the entire process.
2000, the cognizance is taken in 2000, you are coming in 2000.
I can think. 2012 ला सेटा भी प्रोसेस है. पण 2012 कडे आहे माणूस जरा.
Petitioner is an issue notice. Petitioner is issued by the order dated 3/5/2000, passed by Lieutenant SDGM. SDGM Boni in 2CC case number 31 of 2000, whereby cognizance has been taken. Mr. Tank counsel for the petitioner submits that in the present case, without including the company as without owning the company as an accused, the state is prosecuting the directors of the company. Apart from that, along with there is no supporting affidavit. The complainant has not filed supporting affidavit along with the complaint case. Therefore, in view of the judgment of the Supreme Court in Priyanka Srivastava so and so, the complainant is liable to be quashed. Apart from that, he has relied upon the judgment of this court in criminal MC 724 of 2023. Sanjay Kumar Patwari versus State of Orissa and others, passed on 4/5/2023, whereby this court had quashed the entire quashed the proceedings and quashed the cognizance order taken in 2CC case number 93 of 2012 on the ground that the director of the company, director of the company were prosecuted without hearing the company as an issue.
Malas, I am appearing for the opposite party number 1 and 2, Malas.
Proceedings from 2CC case number so and so is state. Yes.
Malas, I am appearing for the opposite party number 1 and 2, Malas.
Yes.
For the union.
Union. Yes. Yeah. I have issued notice and just filed reply. Yes.
Item 6.
Not for the proceedings as
Yes, state. Yes.
And please, your lords. This proportionate asset case sentenced to undergo arrive for 2 years and to pay a fine of 50,000.
With the first case.
First case, appeal, then admission.
Appeal admitted. Be granted realization of the state and call for TCR. TCR. The presence.
Mr. Rizvi, my name? Rizvi.
My lord, I may be pardoned, my lord. Mr. Srimant Das, senior standing counsel's name may be reflected.
Yes.
Srimant Das, he has been entrusted with all the special court matters, my lord.
Yes.
Item 7.
7 here, 3 years convicts.
Yes, same order. Same order. Yes.
So stay and bail.
Stay and TCR call for. Yes.
My name may kindly be reflected in the cause list as well as in the top of the brief, my lord.
Yes,
7 and 8.
that paragraph is fixed for you.
7 and 8. 7 and 8.
Yes. 8 also. 2 years. 8 also. 8 also. Okay. Sentence? 2 years.
2 years.
Yes.
Item 9 and 10.
May I pray 7 and 8 free copy to be given?
Yes, copy they will give, obviously.
Oblige, my lord, oblige.
Yes, we will copy. Doing everything.
Repeat, Your Lordships.
Yes, madam.
Lordships. Your Lordship was pleased to release the petitioner on bail. Page 16 is Your Lordship's order.
1/6. 1/6.
Lordships, 1/6. Subject to verification of antecedent. If my lordship remembers, he had already returned, and he had returned all the amount, and also it's 80% disability. But my friends in the state said that there is no antecedent. Unfortunately, when they verified, they found two, but it is way back. So that is why the order was could not be given effect to, and that is
What are the offences?
you will find it at page 19, third para.
Yes.
For say 420 294 506. Two offences. Page 19 has been referred to, and page 22 that is the verification report. But this is what
Where I have not said that to subject to verification.
Chips has said at page 18.
18.
Chips. Page 18, hence the petition is directed to be released on bail by the court in session. So page 20.
How many cases you have? 2 cases.
On verification before the state, present. So then I think they found two.
I'm sure that only 2. For
Those two. That is what the order also says. Page 22.
Yes, Mr. What do you say? Where is the election order now?
Lordship will find it at page 19.
19.
Third para. Fourth para, Your Lordship. Last 6 lines.
Yes. These are the 2 cases.
And the verification or report is at page 22.
I mean, where does it say that you were on bail on those cases?
Lordship find it in the last para on the same page 19. Third line, he has submitted that in GR case number 67 of 2008, the accused has already been enlarged on bail.
What do you say? Verify.
It is, Lordship is
Verify how many cases we don't know.
page 22.
22, but let him verify. Issue notice. Issue notice for us. Yes.
I can tell you.
Yes. Then. Me asking for time and time. What is? Huh? Yes?
Surrender certificate not yet.
Surrender certificate not yet filed.
Okay.
Lordship, may I request item 9 to be on Wednesday if possible? Because the records are there, so if
Wednesday it will be a tough day. Immediately first day you reopen. Yes. From the fiction. 4 weeks, for a period of 4 weeks granted.
Yes, ma'am.
While order dated 15/5/2024, the coordinated bench of this court had enlarged the petitioner on interim bail for a period of 4 weeks. It is informed that after the petitioner has made the surrender, not filed the surrender certificate before this court. In view of the present petition is dismissed, the trial court is directed to issue appropriate process for ensuring the appearance of the petitioner to face the trial. Yes.
11, my lords, the person is in custody since 6/7/2023, my lords. 6/7/2023.
Yes.
And the charge sheet has been filed on 31/10/2023. That's everything is documentary in nature, my lords. If your lordship remembers this case, the present petitioner operates a online payment gateway in the name of Pay One Services. Now he had a client iSerview, for which iSerview is a company which consultancy services to various people. So it was the payment gateway of that company. So everyone who gives the payment to that company, it will come through this payment gateway. Now, my lords, suppose someone pays 100 rupees to iSerview, it will be uploaded in that payment gateway, and my duty is in T plus 1 day, date of transaction plus 1 day, I have to give it to iSerview. And this is what has happened, and iSerview has settled the payment in my
You are an
intermediary. Now the allegation is that their account, from iSerview's account, 11 crores got transferred to 125 accounts. Now their allegation is I have done it. But as per the charts, They verified the payments were in their account and they have settled my payment. That is the charge sheet, my lords. I given a copy of the charge sheet. Last occasion notice was issued to the informant, my lord. And today I am appearing. At 10:30 I just received the brief. So
Immediately after vacation, first or second.
the person is in custody since more 1.5 months. Like he has my lords, if the informant was really interested, a bail application which has come 10 times before your lordships, what is the amount involved by that? 14 crores.
Last occasion, this was not served. Therefore, your lordship directed to serve the notice through police. And my lord, before that, only lordship kindly see the order dated 6/4/24.
6/4/24. That was wrong submission. Thereafter, in the order, 10,000 deposited, my lord. That's the wrong statement. 24 next. Order number 5, my lord.
Order number 5. Yes.
A statement was made that 2 crores some amount has been deposited. Council was that is wrong, my lord. That amount has not been deposited.
Already deposited.
No, it was not been deposited. On the next date, my lords, it was submitted by us. It is a wrong submission. Thereafter, my lords, the hearing is started on merit.
A council
My lord, had this been the order, my lord.
No, but this is an order.
This is a submission, my lords. By a council who was earlier appearing. Thereafter, my lord, this case has been taken up on merit, my lords. But it is not subsequent orders does not reflect that, my lord.
Have you moved an application?
On the next date, my lords, when it was before justice, before court number 11, my lords, we made a submission that it is a submission. Thereafter, my lords, the court has proceeded. Otherwise, my lords, but submission has not been recorded on record, my lord. That statement has not been recorded on record, my lord. My lord, kindly have a glance at the following order also. On affidavit.
It says that the wrong.
Whereafter, my lord, the matter has proceeded on merits, my lords. That is the wrong.
No, that's right, but some order is there on the face of it. How do you get out of that order?
But there is also.
You see, there are specific 3 or 4 paragraphs.
My lords.
Mr. Narendra Bahadur Tiwari, in counsel appearing for the petition, submits that out of the alleged misappropriation of 14 crores something, a sum of 83 lakhs, my lord, has already been deposited. My lord, that was forwarded, that has not been deposited. How do you get out of it?
That has not been deposited, and that order has not also been recalled.
Sir, ये जो से कोई ना डिपोजिट
This is a problem for me. How do you get out of this?
Here, this is.
No, wrong submission. Now you are saying how from the record how it will be evaporated unless something you say.
My lords, I don't know, my lords, those circumstances I cannot explain.
Then you need to file an affidavit. Otherwise, this will spoil in the face of it.
Petitioner will file an affidavit.
File an affidavit. Wrongly submitted. This was never done. Something has to come on record to know.
I think they have done it, but it was an error on the part of that council, my lords.
Maybe I don't know. I mean, instruction he has said. Unless the same council would have continued, that's a different story. Now they have changed.
I understand.
So that might be a reason.
Well, under that,
I don't know.
power is also with sir, my lord senior.
That has
Like
been.
senior can't give the power.
No, senior has not given, but he has power. He has not changed the, because with his associated.
Let him file an affidavit. Clarify this.
Affidavit.
Make it immediately after vacation, and in any case, he's taking time today.
My lord.
I will file my wakalat in course of the day.
That part has to be taken care of.
Yeah, my lord, because that was.
All document evidence. That's all. Because he is already there in
If my lords allows him on bail, subject to the condition, only one condition is that 50% of the amount will be deposited. Because that has been there, that will be decided in the trial itself, my lord.
construction. And at one point in time, I think he would have been able to deposit some money. Therefore, this statement has come. You just ask, I'm not saying anything. I'm simply urging it. This is what his submission is. And moreover, the obligation to pay. But he says that something should come.
My last officer also stated, my lord senior will take instruction that will deposit.
You persuade the client and otherwise deal your merit.
Because it is all
something. You can't keep someone.
We are not against that, but based on that, the money should be recovered, my lord. It also doesn't belong to the state of Odisha. It is an outsider.
My lords, if money.
So once he goes out from there, there is every chance of account, my lord.
SBI, will the UPI, my lords, like Paytm or other, my lords, bank holder, I mean, card holders be held responsible? We cannot misappropriate it. We have been showing to your lordships. My lords, because it's a new arena.
No, if his case is also believed, the money has been transferred to different account. It has not come to him.
By manipulating the QR code. By manipulating the QR code. Yes, ma'am. My lord. The detailed instruction I will take, my lord,
The money hasn't gone to his account. According to the prosecution case, and
the law says that it has been.
Well, to his account. Actually, it is a dynamic QR code.
They have manipulated the QR code. They have manipulated the QR code. It has been made to that manipulated.
the fact remains that these are documentary evidences.
Yes, ma'am.
Documentary.
That will
So 1 year, 1 year, 1 year more.
but subject to condition, he has to go.
Let him come with some money, not that 50%, whatever.
My lord, I will also.
But once he release, then only will pay. What I'll do is I'll pass an order for release and direct him to, after release within 1 month or so, we
Sir,
will.
because there is paucity of time, the holidays are approaching.
Yes.
My friends are also waiting.
Immediately.
I'll go into, I'll argue this matter at length. It's not possible that he could have misappropriated. Only thing that stands as a hurdle in my way is this statement.
File affidavit.
Well, I'll file an affidavit explaining we had never given such instructions to the previous, council.
Well, yes, yes.
But after the
Unless it's immediate. He will file the.
I will find the Bakana before the
And take evidence on behalf of opposite party number 2. And seeks time for filing the response. These two matter. Yes.
Yes, ma'am.
My lord, item 13, my lord.
Yes, yes.
My lord, may it please your lordship. My lord, that case, the accused is staying in custody, my lord, 4/9/2023, my lord, under section 302, 120B and 34 IPC, my lord. In this
Yes.
regard, my lord, yeah, another bail application, my lord, also rejected, my lord.
Yes.
My lord, other
My lord.
co-accused, my lord. And
Other co- And what are I saying? I said that after material witnesses are examined.
my lord, my lord,
Well, that is your lordship have
my lord,
earlier reject the bail plea on the merits and on the ground that the investigation was still going on the point in time. Land council.
That has been filed now.
yes, my lord, charge sheet already filed, my lord.
And this petitioner who has been rejected.
When the charge sheet was filed? Charge sheet filed on?
My lord,
When?
File, my lord.
my lord, 31/12/2023, my lord.
Petitioner is agreed by the order dated 21/12/2023.
31/12/2023.
Subsequently thereto, the charge sheet has been filed on. This is Bharat. And in view of the subsequent development.
And my lord, one it has been filed 1/2024.
1/1/2024. And on the changing circumstance, petitioner may review the bail plea for the trial court. Yes. Yes, next.
All right.
December 1st, yes.
15.
On VC Milan.
Yes, sir.
I am on VC Milan.
Yes, yes, yes.
This is a case of 2021. That is the brief. On 30th of October 21, the Damanjodi police found a car abandoned near an SBI, State Bank of India at Damanjodi. They
Yes.
recovered 197.900 grams from the contraband ganja from that car. There was none in the car. Then the car belonged to one Trilochan Machi. So when these police people contacted Trilochan Machi, he gave a statement that the present petitioner has taken away his car and he has not lodged any report. Basing on his statement, this present petitioner is now in jail custody.
My lord, the whole fact is, my lord, the ganja has been seized from the concerned car, Swift car, not the Swift. 1 quintal, 97 kg, my lord. And we were just before near ATM, in front of the ATM, my lord, that's the ATM. But at that time, the three persons were freed away from the, because due to the problem in the vehicle, my lord.
Yes.
And while police investigation, just an investigation is done, and that he found that who is the owner of this vehicle. And the vehicle of the real registered owner is Trilochon Majimela. So we can just on reading the statement of that.
Who is this Ghanshyam Maji?
Ghanshyam is the person who was given land to this vehicle owner and took this vehicle for this purpose, my lord.
Okay.
Ghanshyam. will get the information. 14 दिन घरे थोड़ा समय हम घर को दामनगढ़ में पुलिस का गाड़ी मारी तो सुपी कार नंबर 1 से बिसर बच्चे लोग कहली के गाड़ी में किछि वर्ष होला तळे 3 लाख टका देई सेकंड हैंड बुक किनथिली मो बगे टंका मिथिले घनश्याम माझी पड़े 2 लाख ताकू कहथिली रिस्ट्रिक्शन में ताकू कहथिली मो गमी विभाग कंपनी तरफ टंका मिलबो ସେଇଟା ମିଳିଲେ ମୁଁ ତୋତେ ଇଣ୍ଟରେଷ୍ଟ ଯୋଜନା ଅଧିକ ଟଙ୍କା ଦେବି ଏଇଭଳି କହି ଘନଶ୍ୟାମ ମାଝୀ ଠାରୁ 2 ଲକ୍ଷ ଆଣିଲି ମୁଁ କିଛି ଟଙ୍କା ମିଶେଇ ମାରୁତି ସୁଜୁକି ଗାଡି ଯାହାର ନମ୍ବର 1 କିଣିଥିଲି କିଛି ମାସ ଚଲେଇଲା ପରେ ଦିନ ହଠାତ୍ ଘନଶ୍ୟାମ ଆସି ମତେ 1,000 ଟଙ୍କା ମାଗିଲା ଇନ୍ସପେକ୍ସନ କହିଲା ମତେ ଏବେ ଟଙ୍କା ଦରକାର ଅଛି ମତେ ଟଙ୍କା ଦେ ନହେଲେ ମୁଁ ଗାଡି ନେଇକି ପଳାଇବି ଯେହେତୁ ମୋ ପାଖେ ଟଙ୍କା ନଥିଲା ମୁଁ ଦେଇପାରିନଥିଲି ଘନଶ୍ୟାମ ସେଠାରୁ ମୋ ମାରୁତି ସୁଜୁକି ଗାଡି ନମ୍ବର 1 ନେଇଗଲା କିଛି ଦିନ ପରେ ତାରିଖ ମନେ ପଚରା ଉଚରା କରିବା ପାଇଁ ଡାକିଲେ କହିଲେ କି ଗାଡି କୋଉଠି ଅଛି ମୁଁ ସେମାନଙ୍କ ବିଷୟରେ କହିଥିଲି ସେମାନେ କହିଲେ କି ମୋ ଗାଡି କୋରାପୁଟରେ ଗୋଟେ କେସରେ ସିଜ୍ କରି ରଖିଛନ୍ତି ତାପରେ ମୁଁ ସେଦିନ ଯାଇ ଘନଶ୍ୟାମଙ୍କୁ ମୋ ଗାଡି ବିଷୟରେ ପଚାରିଲି ସେ କହିଲା କି ତୁ ଚିନ୍ତା କରନା ମୁଁ ଘନଶ୍ୟୁ ଅନେକ ପ୍ରଶ୍ନ ହେଇଛି ଘନଶ୍ୟୁ ବିଜନେସ୍ ଘନଶ୍ୟୁ ସେ ଗାଡି କଥା ବୁଝିବୁ ମୁଁ ମୁକୁଳର ବ୍ୟବସ୍ଥା କରିବୁ मोर नारे गाड़ी थे घटना विषय में किसी जानी पर सुविधा घनश्याम आउ तार सांग घनश्यू साहू मिसिकी मो गाड़ी गंजा व्यवसाय करते घनश्यू आउ साहू ना पुलिस केस अच्छी
घनश्याम माजी
No statement belong. After 3 years, about 3 years after, that statement is recorded by the IO. After 3 years, occurrence is 21, 24, that statement.
The occurrence is taking place on
30th of October 21.
30.
This person was absconded since from that incident.
You were absconding.
And charge has been filed by showing to him as the absconder.
Absconder.
Yes, ma'am.
Yes. You are absconded, sir.
My humble submission is no record is there, sir. At least that this fellow was not found at the place of detection. He was not found. There is no record to actually tag him.
What is the stage of the trial?
The owner of the vehicle, he is escaping away, throwing the blame onto this Ghanshyam Machi. Not even a single document. If Ghanshyam Machi has taken that car in the year 21, then why he has not reported the matter to police? Nothing is there, man. Actually, the real
rejection is 2024 mailer.
Yes.
And charge sheet has been submitted 30/08/2024 mailer, August 2024 mailer.
Because the investigation stage that you have applied for it. The petition is agreed by the order dated 19/3/2024, whereby his bail plea has been rejected. Subsequent thereto, on 30th August 2024, the charge sheet in the present case has been submitted by the police. In view of the changing circumstances, petitioner may renew the bail plea before the trial court affairs, and if such bail plea is moved, the same shall be considered on the basis of the forms part of the charge sheet. With this observation, the petition is disposed of. Yeah. Next. 16.
This is a case of consent, allegations of rape she lodges an FIR in 2013 saying that, 23, sorry, 24, my lords, she says that I have been having a relationship with the petitioner since I was 17. And we have been continuing this relationship.
Custody since?
Custody since 24/11/23.
23, okay. Yes.
And
164.
164, my lord.
This boy is also 25 years.
And FIR was lodged when the victim was 19 years.
19.
19. She, to attract to POSCO, she has stated that I have kept a relationship since when I was studying at 7. The 164, that is 5. That is also considered BD, but
They were in relationship. Was recorded under section 164 CRPC. Was recorded under section 164 CRPC. She, in a statement, is stated that in the year 2017, when she was 17 years age, she had relationship with the present petitioner. The petitioner, on the assurance of marriage, has committed sexual offences, sexual assault on her, and subsequently legaled out of it. The FIR was registered on 23/11/2023. 2023. After about 6 years of alleged incident. Petitioner is in custody since 24/11/2023. Regard being heard to nature of the accusation and the period of custody from 24/11/2023 granted. Yes.
17.
Item 17. May I please? This is on the section 498A. 302, 304B of IPC for the custody since that should be 12/11/2023. You are about 1 year. Yes. You are about 1 year. Husband. 61.
husband.
Husband, lots, yes. 161 statement of the 304B. 304B. Yes, yes, sir.
304B, 302.
302 is also there.
Charge sheet submitted.
Okay.
But my lord, in the rejection order, my lord, it was stated as 306.
When the charge sheet 306 started?
My lord, charge sheet was submitted on, preliminary charge sheet was submitted on 2/1/2020.
Yes.
And my lord, in the rejection order, wrong, it was stated as 306, my lord. Rejection order.
302 in fact.
But actually, charge sheet submitted on 302.
Yes. 161 statement of the informant as it clearly stated that line. Yes.
The petitioner is in custody since 10 to 2024.
10 to
24. The petitioner is not the main accused. It is alleged that he has helped his brother-in-law, who is the main accused. And 164 allegation I have annexed. As the co-accused, not against me.
Yes.
My lord, he is the petitioner is the brother-in-law of the principal accused. His role is that, my lord, he has only facilitated the victim to fade away with the principal accused.
Only
that reason, my lord, charge sheet was submitted under section 366, 363, 109. Only notice was issued, but notice is not required because 303-763 is there against the principal accused.
So the petitioner is accused in so. The allegation against the allegation in the FIR is the petitioner is it is alleged against the petitioner that he has aided the principal accused. What is the name? Principal accused?
Vishnu Sikka, my lord.
Vishnu Sikka for committing the offense of kidnapping and subsequently committing sexual assault on the victim. Sexual assault on the victim. Petitioner is in custody since 10 to 2024. Regard being heard to the period of custody and the nature of allegation and the fact that the petitioner is only aided the principal accused for commission of offense. and there is no overtake, a specific overtake attributed to the petitioner, I am inclined to enlarge the petitioner on bail and grant.
Here, my lord, one noting is that registered post is not yet completed. That may be reflected that the charge sheet was not submitted under section 376 or notice.
Since although the notice was issued to the opposite party, to the informant of the victim, however, the notice could not be served. It is made could not be served. Since the charge sheet has been filed under section
366, 363 and 109.
109, notice on the informant or victim is not required. Hence, the notice is dispensed with.
Well, charge sheet is submitted only against the petitioner under section this section, but principal accused 376(3) is there.
Yes.
20.
19 addition.
Lordship, may I be permitted to place on behalf of Mr. B? Yes. Lordship, custody since 25 2023. 25 2023, Lordship.
Yes.
Lordship,
24.
23, Lordship.
23. Yes.
Lordship, initial FIR was lodged against unknown person. Alleged offence under section 302. Initially, FIR was lodged that the informant received a call that his son.
What happened? Charge sheet has been filed.
Yes, Lordship.
When?
On
15/9/2023, Lordship.
Yes.
under section 302.
302 is the Lordship.
Yes.
Initially, the FIR was lodged that one dead body was found, and the informant went and said that he's the son-in-law of the informant.
Yes.
Subsequently, Lordship, in the charge sheet, it has been categorically stated that the petitioner as well as deceased went to an omelette shop and had their omelette. Subsequently, after that, his son-in-law was missing, and he was entitled in this case. Subsequently, on the basis of leading to discovery of the knife, he has been implicated, Lordship.
What are the
Last in theories, my lord,
Last in
was
theories,
CCTV
Lordship.
footage and others witnesses stated they were present. Leading
Knife was seized from
And
the
my lord, another thing is that, my lord, when the petitioner was arrested, he has gone to the urinal in the police station. And at the police station, my lord, he has tried to commit suicide by taking the broken glass of the latrine. For that reason, also 309 against the petitioner was registered a case against the present petitioner 309. And my lord, the last year, my lord, 164 statement. May I read that portion?
164 of who's 164?
My lord, one of the witnesses who has seen the both persons.
Mhm.
Last in theory and also CCTV footage, it was also recorded.
Yes, yes.
And the minor son of the deceased, he has also had the telephonic transaction, telephonic conversation between the deceased and the petitioner.
Yes.
And only two witnesses were examined, informant and one other seizure witness. They are not the material witnesses, ma'am. And madam, I'm reading.
What is the stage of the trial?
Trial is going up.
Five out of 65 witnesses have been examined.
65 witnesses.
Yes, Lordship.
The material witnesses are examined.
No, not examined. Only
No, Lordship.
Material witness according to you.
madam, that's one Jagannath Badi,
Jagannath
Jagannath Badi, BADA,
Badi.
BADA,
Badi
and Dibakara Hansa,
Dibakaro.
Hans, HANS, Hans. And another one, minor son, that is Sibo Mohanandia.
Shivam.
Right.
They are the last in theory.
Last in theory and the telephonic conversation between
Right.
the minors.
Petition is accused on counsel case. The allegation is the petition counsel. The perusal of the evidence form part of the charge sheet reveals that Jagannath Body, Dibakar Hans, and Shivam are the vital witnesses. Those who have lastly seen the accused with the deceased person, and they have also witnessed to the conversation between the deceased and the petitioner. These two witnesses, out of 65 witnesses, 5 witnesses have been examined. However, the material witnesses, as named above, have not been examined as yet. Therefore, I am not inclined to enlarge the petition on bail. However, liberty is granted to the petitioner to renew the bail plea after these three above named 3 witnesses. The trial court is it is expected that the trial court should do well to see that these three witnesses are preferentially examined over all other witnesses. Yes.
But that is out of 62 charge sheet witnesses, not
62. 62. Yes.
21.
Yes.
Tell me, please, Lordship. FRL is offering 2N, 2Y, 94,506 IPs of his. But Krishna custody, Lordship, 18, Lordship. In the meantime, the matter settled between both the parties, Lordship.
for the informant. And his
Victim.
376, 376, 2N, madam. Victim was,
Major girl, 35 years.
victim was pregnant. Other is the eyewitnesses who was given information for FIR he has given. And she was a mentally abnormal lady. Certificate is there. How it will be settled, madam?
With whom you have settled? With whom you have settled?
With informant.
With informant, Lords.
Informant is for this court, my lord.
What about the victim?
Victim was already given the affidavit, my lord.
How is he? Is he mentally retarded?
It cannot be compromised, madam. This type of offense
He is
is not
mentally retarded. Show me some document.
160, that is a,
Mentally retarded.
this is the certificate.
You are 44-year-old man.
44.
What is the age of this girl? 35 years old. Mentally retarded. And, no.
60%, madam. And she was pregnant.
Custody since coastal lordship 18/3/24 lordship.
She has seen the picture.
What is the affidavit of father? To me? What she says?
I've already filed, my lord.
What she says? In front also present lordship before court. No, what she says in the affidavit. Who is that subscriber?
My lord.
Badi. ଆପଣ ଏଇଟା affidavit ପଢିଛନ୍ତି? ଆପଣଙ୍କୁ ପଢିବା ଆସୁଛି? ଆଜ୍ଞା? ଆପଣ ଦେଖିଛନ୍ତି ଆପଣ ତ ଓଡ଼ିଆରେ ଇଏ କରିଛନ୍ତି ଦସ୍ତଖତ କରିଛନ୍ତି ଆଉ ଇଂଲିଶରେ ଏଗୁଡାକ ଲେଖା ହେଇଛି କଣ ଲେଖା ହେଇଛି ଆପଣଙ୍କୁ କୁହା ହେଲା କଣ କଣ ଲେଖା ହେଇଛି କମ୍ପ୍ରମାଇଜ ବୋଲି କୁହାଯାଇଛି କିନ୍ତୁ କଣ ଲେଖା ହେଇଛି ଜାଣିଛନ୍ତି ଆପଣ ଆପଣ ଏଫଆଇଆର କାହିଁକି ଦେଇଥିଲେ ଏଫଆଇଆର କାହିଁକି ଫାଇଲ କରିଥିଲେ ପୋଲିସ ଥିଲା ଆପଣ ଝିଅ ପୁରା ପ୍ରେଗନେଣ୍ଟ ହେଇଗଲା all these things are dicey things, very dicey things.
And 164 statement of that information. Only I have marked.
These things can't be, see, on merit you may get the deal, but this SAR practices, influencing the witness, getting the affidavit, and all these things further down.
And one is for the informant.
The complexity is confirmed.
That portion I have marked.
Yes.
One is for the informant, another is for the victim. Both are filed affidavit that.
Verified. Shastri submitted or something. Maybe a merit I could have given, but the manner in which you are dealing with this is very unfortunate. On merit you could have argued. On merit you may be entitled to win, but why are you influencing? Why you need 2 lawyers for that? Petitioner is accused in so case. Allegation against the petitioner. The informant, with the father of the victim, the statement of the informant with the father of the victim was recorded under 164 CRPC. He has made specific allegation against the petitioner. It has come on record that the victim is a disabled, 60% disabled girl, and she was pregnant by the petitioner. When the matter was heard before this court, the petitioner submits that they have settled the dispute. Even the informant is present in the court and has filed the affidavit. On behalf of the victim also, an affidavit has been filed through another counsel. In the affidavit, both the victim as well as the informant has simply stated that they have settled the dispute and on the intervention of the well-wishers and the however, nothing is said in the affidavit as to why the FIR was registered and what is the present status of the victim. Regarding to the aforementioned, the IIC of which police station?
That is Banapur.
Banapur is directed to verify the veracity of the affidavit furnished before submitted before this court and file a report regarding the well-being and the health condition of victim on the next date of hearing. Please the matter immediately after the case. Yes.
And they may be directed to serve the copy of that affidavit.
Serve the copy. Serve the copy. Yes. Next.
22.
Please, Honorable.
Yes.
May I please?
Yes, sir.
There is a case where the prisoner is 32 years, in informant become victim is 29 years. And the offense 376 2N murder, 379 along with 66 and 67 IT Act.
164.
Custody since no, in the meantime, the victim has also been examined as PW.
Yeah, custody since you just
6/7/2023.
6/7/23.
More than 1 year, 2 months.
Yes. So.
But when it's 66, 67 IT.
And last time it was my content.
And nude photos also seized from the 7 numbers of nude photos seized from the presentation.
Have you ever seen this statement?
No, not.
I'm passing the word. I'll just come.
And it was my contents last time that nothing has been found in the internet, and all these things which has been found in the it is in the mobile of the present victim.
We'll see. You are already there in custody since 1 year. Let us see.
Question first, see para 2, 3, then matter.
Yes.
Yes. The month of no called me to
The admitted relationship through Instagram and also things. Number was exchanged. And it is also not case that she has paid some amount to phone pay to petitioner. and one gold chain. The gift.
Where did she say that she was in relationship with her?
Madam, see, page, madam, see, second page, third page, para 12 onwards, madam.
Para
Para
12.
12, 1 to 1.
Cross examination, no?
Yes, sir.
Okay.
It is a fact that, madam.
I mean, highly educated and worked in a different field, and I know that.
It is a fact that on such and such. Night time, such and such, there are consistent talk between them. I was on video call with the accused. During the time of such video call, the accused was staying at Bangalore as well as sometimes Jagatsinghpur. Thereafter, madam, skip that. Para 16. It is a fact that during my stay at Bhubaneswar, the accused had kept physical relationship with me for some time. It is a fact that prior to physical relationship with the accused, I was frequently talking with him. Thereafter, madam, skip that.
What is the
regarding
relationship para 15, madam.
Yeah.
Basic thing only. The marriage.
It's not the fact that I was
I'm not a.
And
living places.
so, but the amount of transfer also seems that seizure of this allegedly the photograph that will turn to place.
Not the fact that I mentioned the
The accused had sent photographs and video to my email, not to anybody, madam. The police had seized the same. I have also submitted my email ID to the police. The police had collected the videos and nude photo which I have received from the accused. So, there was an exchange of these. So, in widespread one, it was single evidence that I had spread it through email, I have no case. So, it was an exchange.
21, read 21. Read 21. It is a fact that in several occasions the accused has sent money to him, money to me. Or in those occasions he requested me to withdraw the said amount, and accordingly I have given the said money to the accused. That after withdrawal from ATM, it is not a fact that I have returned the. It is not a fact that the document has been false.
And para 24 and 25 was required consolidation. Consensual says relationship was there. 1 year, 2 months.
Yes.
Is an example, so there is no chance of
The fact that
influencing.
which accused uploaded the fact that I cannot see. Which accused uploaded.
And so far, the IT Act offense is concerned because it was not sent to the email, no offense. It was just an exchange between the parties. And the photographs allegedly it was seized from the mobile of the informant.
That the accused has not circulated. It's not a fact that. Yes.
Well, actually, it was not uploaded in.
It's not uploaded in Facebook. She is 29. And there is a money transaction. See, it's a complete consensual thing.
Consensual. And
the relationship, what to do? And see, it's not that one side, 1,40,000 rupees, she says that he has taken. At the same time, in cross-examination, she says that at times she also has taken money from.
That is the bank transaction detail.
The money was transferred, the relationship was there, and everything was there.
Relating to photograph matter, that was not uploaded.
And they have taken the photograph and see the relationship is very apparent. Radom, petition detectives in allegation. The victim, who is 29 years of age, has been examined as PW2. The perusal of the evidence adduced by the prosecution, particularly the evidence of the victim, lead to the inference that the petitioner and the victim, petitioner who is what is this? Petitioner who is 32 years of age has been in relationship with the victim. They were staying. They were staying in Bhubaneswar. They were staying in Bhubaneswar and Bangalore. And during their stay, they had sexual relationship. Now, there was some money transaction, and it appears from the cross-examination of the victim that at times she has also taken money from the petitioner and vice versa. And it has also came on record through the evidence that the photographs and videos recorded by the the petitioner was sent to the victim in the email. However, nothing is illuminating from the record that as to whether those photographs and videographs were viral through social media. On the contrary, the evidence is otherwise. Evidence is otherwise. The petitioner is in custody since 6/7/2023. Regarding head to the evidence of PW, evidence of the witnesses already recorded by the prosecution, particularly evidence of PW to the victim. I'm inclined to enlarge the petitioner on bail and so on so. Yes.
23. Madam, may keep it a part of that. Only one prayer, but in the meantime, the case has been committed. Madam, may indicate the court station. And ST case number 58 of 2023. Madam, may keep it.
ST case is there.
It is the top of there. ST case of 58 of 2023. In the file of planning additional session judge.
Yes.
Anand. Okay.
Yes. Next. Yes.
It is my husband, Madam. Custody since 2024.
28 to
February 28
to 23.
24, Madam.
24, sorry. Yes.
Charges submitted on the 498, 304, 306, and 306.
Show me. How she died?
Hanging, Madam.
Hanging. Show me.
Unnecessarily postmortem report, Madam. I'm unnecessary.
Actually, rejection was made on 18/4/24 when 302 was there. Charge sheet was submitted on 26/6/2004.
26/6/2004.
2004.
Then you when it was 302 was rejected.
So not granting bail, Madam. Many cases.
You are in custody since February
22.
28/4/24.
Show me what are the evidences.
My evidence, he was alleged witness.
Was he present in the present when the incident had taken place?
Well, he has bolted the door. That is the first thing.
Where is that?
Well, the witness is stated, but my lord, actually it is a faulty prosecution and faulty investigation, because I am reading one statement that those neighbor who has stated, my lord, that who has tried to rescue the victim neighbor.
Door from inside and committed suicide, despite the efforts made by the family members, including family members. The deceased did not open the door. However, the three-year son who was with the deceased eventually opened the door. It has come on record that charge sheet is in file, huh?
Yes, charge sheet was submitted on 26/6/2004.
Submitted on for alleged offence under section 30498.
06 and 406.
Received for alleged offence under section 308 and allied offences. The petitioner is in custody since 2022-2024. Regarding head to the nature of acquisition, period of custody, and the fact that the wife of the petitioner has committed suicide, bolting the door from inside the house, from inside the room. I'm inclined to enlarge the petitioner on bail. Yes.
24.
Maybe was it.
Yes. Was there any direct assurance of marriage? She has given consent for he has given consent, and the petitioner has committed sexual act on her. The petitioner is in custody since 23/3/2024, and the charge sheet has already been filed in the present case on 18/5/2024. Regarding head to the paragraph. Regarding head to the period of custody and the age of the victim being 19 years, being 17 years now. Now, FIR was registered on which year? 24. Regarding to the age of the petitioner being 19 and the victim and period of custody, nature of litigation, and the nature of litigation and crime. Yes.
Petitioner is in custody since 27 October 2023.
27 October, huh?
Yes, my lord. And offense under section 302. And here, informant is the husband and lodged a FIR against his wife, alleging that her wife is responsible for the death of his son, my lord. This is the allegation. But in her evidence, I have given the evidence copy, BW1. She has stated in her cross-examination, it is not a fact that before the incident, my son was with me in my garage. My wife was taking care of my son during going to the tuition or school. And she has stated in cross-examination also that I, along with my wife and son, were living peacefully. Have you seen it?
Yes, yes, ma'am.
Yes.
That one of the material witnesses that PW6 man. That PW6 reports about seeing the accused throwing her son to the tank through CCTV footage. It has been established, madam. That's the PW6 not a twin examined, madam.
PW6,
madam. Who is the material witnesses in this case?
PW6 is examined.
So the examined, madam. The question copy.
The question is that PW6, what is the name?
No, madam. Sudarshan. He's not PW6. PW6 is the malad informant. Here one Sudarshan, my lord.
Sudarshan has not been examined.
Sudarshan has not been examined because he is the prime witness and in statement.
She has not been examined. Out of 22 charge sheet witnesses, only 8 witnesses have been examined.
Material witness. Sudarshan and
only Sudarshan Das is the material witness, my lord, here. Sudarshan stated, I am reading, my lord, his statement. ସମସ୍ତେ କହୁଛନ୍ତି ଯେ ଆମେ ଦେଖିଛୁ ବନ୍ଧରେ ଟାଣି ଟାଣି ପୁଅକୁ ନଉଥିଲା ଏବଂ ପୁଅକୁ ନେଇକି ତାପରେ ଏସବୁ ଜିନିଷ କହୁଥିଲି କିନ୍ତୁ ସୁଦର୍ଶନ ତାର ସିଏ ହଉଛି ଗୋଟେ ସୁଦର୍ଶନ ମୁଁ ବିଜିପୁର ବଡସାହିର ଏସ୍ ପାପାକୁ ଜାଣେ ସ୍ତ୍ରୀ ନାମ ଏସ୍ ଗଙ୍ଗାମା ସେମାନେ ଗୋଟେ 8 ବର୍ଷର ପୁଅ ଥିଲା ଯାହାର ଏସ୍ ରୋହିତ କୁମାର ଓରଫ ଶ୍ରୀନୁ ମାଇନର ସେ ବିଜୁପୁର ବିସିଏମଇ ସ୍କୁଲରେ 3ୟ ଶ୍ରେଣୀ ପାଠ ପଢୁଥିଲା एस पापा गिरी रोड रे बाइक रिपेयरिंग दुकान करिछि मु बीएमसी रे सुपरवाइजर काम करे बिजुपुर बड़ बंद पाखरे मु गोटे ऑफिस के अछि सही ऑफिस तारे सीसीटीवी लगाइछि गतकाली 26/10/23 रे राति 7टा रे मु मोर ऑफिस तारे बसिथिली एही समय रे मु देखिली जे एस गंगामा ता पुओ एस रोहित कुमार को बिजीपुर बंध पाखे जोर जबरदस्ती झिकी झिकी नेउथिला प्रायतः
let this witness be again.
Here, my lord,
out of how many witnesses?
Total witnesses are 22 charge sheet witnesses.
8 witnesses have been examined.
And my can you have a glance to
unless that witness is examined.
Cross examination of then the petitioner is suffering from mental disease, my lord. She has stated, can you have a glance to
Okay, I am giving you within 1 month that witness be examined. Right on. Petitioner is accused in so and so case. Out of 22 witnesses, 22 witnesses, cited witnesses, 8 witnesses have already been examined. However, one of the material witness who has seen the occurrence, allegedly seen the occurrence, namely
Sudarshan
Das has not yet been examined. Therefore, I am not inclined to enlarge the petitioner on bail unless the said witness is examined. The trial court is directed to see that the said witness is preferentially examined within a period of 1 month. Hence, thereafter the petitioner may renew the bail plea. Yes, next.
26.
Yes. 26 year also, my lord, that the victim through the IAC also present in DC, my lord. That is all of
16/3/2024.
24. Okay. Tax sheet submitted.
16/3/24. Okay.
Tax sheet has been submitted. 30/6/2024.
That's it?
Tax sheet submitted.
When?
So 30/6/2024.
30/6/24. Okay. What are the offenses?
392, 25, 1 arms act.
One B A and under section 397, 27, 25, 6 Arms Act, my lord.
Arms Act is of.
These are all contest.
What are the allegations?
Yes.
Tell me what it matters. That the petitioner, my lord, confessed is guilty. They have a recovery of a raw gamma, my lord. That's a gamma has been recovered, my lord, and 10 numbers of series of criminal antecedent against the petitioner.
And that's the whole problem, right?
And that is habitual.
1 minute. Petition is agreed by the order dated 25/4/2024, whereby his bail plea has been rejected. Subsequent thereto on 30th June 2024, the charge sheet in the present case has been filed. In view of the changing circumstances, petitioner may renew the bail plea before the trial court. If such bail plea is moved, same shall be considered on the basis of the material which form part of the charge sheet. With this observation, petition is disposed of. Next, yes.
But dispose of
Disposed. Yes.
There is a delay of filing in refuse actually. 1 day delay. 23 it should have filed. We have filed on 24/9.
The recusal is filed belatedly. Utilize the same requisites for the purpose of serving opposite party. Number 2 is the matter of yes.
old man.
Yes. 57 years is not old man. Don't say 57. Your first sentence is negative.
Suicide to them.
They have rejection copyright state election.
Apart of sympathy ground on the basis of your age, what else you have to tell me? I mean, call proceeding. Yes. And next time don't say 50 old man. Huh? 57 is no more old. Yes.
Just like mad little.
Yes, sir.
The case where the petitioner in custody for commission of
Inquiry has come. Yes.
302, my lord.
Yes.
Initially, number of persons were implicated in the case. And ultimately, it was found that the case is based on this statement of one eyewitness who alleged that the petitioner assaulted by a stick on the head of the deceased and leading to discovery of the recovery of that stick. In the mean period, all the 3 witnesses were examined, none of them supported. Neither the leading to discovery witnesses supported.
Have you seen the evidences?
I have given them.
Yes. Tell me. Anybody supported?
No.
Leading to discovery. What happened? Yes, basing on statement law that I will tell you. I'm leading to discovery. Postmortem report is there, and report reveals. Yes, after 4 injury blocks, the head and other part. And that stick also recovered.
But recovery witness has not supported the case. The recovery part goes.
Medical, that can be.
Custody since 24. My friend's objection may be recorded. He want to say.
You are saying there is nothing. You tell me. See, what is the role ascribed to this witness? Sorry, this accused. And what are the related documents?
These actions are asserted on the head of the deceased.
That is on the basis of confessional statement.
Yes.
No. There is the eyewitness.
Who is the eyewitness? EW? 3.
He did not support the prosecution case. And declared hostile. And PW1 and 2 are the witness to the leading to discovery. They did not support.
Cross-examination, have you read it? It's not like that. I along with 6 person said, para 3. Mahima.
I along with 6 to 8% had gone to the Mohima on the day of occurrence, and that at about 4 p.m. we saw correspondent advocating friendly language to the Pradhan, the deceased, and the asserted to the deceased by Mr. Sandalwood, talking backside on his head and advocating saying friendly language. As a result, Sudhir fell down and became unconscious, and thereafter accused fled away from the spot. And I saw there was a problem bleeding from the head of the deceased, and I called the deceased, but I did not.
That position is denied. That's denied. And what is recovery? Recovery. They are also not. But petitioner is accused of allegation against the petitioner also. The petitioner is implicated in the present case on the basis of the evidence of eyewitness Ananda Lordship Banchor. And son of Ananda. Yes. And on the basis of the recovery, effective recovery of the weapon of offense, inverted comma lathi, stick, recovered from the petitioner, on disclosure, on his disclosure. The 3 witnesses have been examined by the prosecution till date. Out of total 30. The 3 witnesses those who were examined are vital to the prosecution to substantiate the allegation against the present petitioner. TW1 and 2 are the witnesses to the seizure of the lathi from stick from the position of the petitioner. These 2 witnesses have wriggled out of their earlier statement to the police, and therefore they were declared hostile. Therefore, insofar as the recovery of the weapon of offense under section 27 of Evidence Act is concerned, there is no substantive evidence came under court. PW3, the eyewitness has been examined as PW3. The same witness was also wriggled out of his earlier statement, as a result of which he was declared as hostile. The said eyewitness has sustained elaborate cross-examination by the prosecutor after declaring him as hostile under section 154 of section 154 of Evidence Act. However, on the cross-examination also, nothing could be elucidated from the said witness. In view of the aforementioned, the petitioner is entitled to bail at this stage. The petitioner is in custody since 2/1/2024. Regarding head to the nature of evidence collected by the adduced by the prosecution till date, since there is no and period of custody, I am inclined to enlarge the petition and bail. The objection will do. This counsel for the state, however, vehemently opposed the bail prayer made by the petitioner on the ground that there are how many witnesses? There are 30 witnesses cited by the prosecution. Out of them, only 3 witnesses have been examined. Mr. Mahapatra and counsel for the petitioner, on the contrary, submits that the 3 witnesses, those who have been examined, are the vital witness to the prosecution. Since they have not supported the prosecution, all the petitioners cannot be put to incarceration, can't remain in incarceration till other formal witnesses are examined. Regarding to the above granted. Yes. With all conditions appear in the court and all. Yes. Not seek adjournment in the, during the trial and all. You will not seek adjournment also. Yes. Not seek adjournment during the trial, appear in each and every condition. Yes. Yes.
May I please? 21D of the NDPS Act, 126 gram of brown sugar seized to the police.
CD. Yes.
Custody since 10/5/2024 and no criminal antecedent.
10/5/2024. One.
No criminal antecedent.
Recovery.
126 gram.
126 gram.
My God.
150 grams from the council position Miller and also city review Miller. How nothing argues
126 gram custody from 10/5/2024 and no antecedents. Okay. And one every month once before police. 6 months. Okay.
That is TR case number legal and weapon. TR case legal and agree with the PR.
You will writing.
Yes, please.
Yeah.
35.
May I please? In this case, petition custody 6 months 23 and 24 minutes. 23 minutes. Yes, ma'am. He has been prosecuted for the alleged commission offences 294 and 304 of IPC matters.
Yes.
Allegation matters for the petitions. Yes, ma'am. Statute filed on matters 3015 2024 matters.
24.
Yes, ma'am.
Okay.
Allegation matter of the petition and approve the district matters. Approve the district matters. The petition abuse plan on the district matter and post provision matters held on the hot water matters.
Hot water.
Yes, matters.
Okay.
There was a marriage feast of the nephew of the informers and the infant and the deceased along with the other matters relatives were engaged for preparation of the feast matters. And they were matters boiling the waters for the
boiling water or boiling
any of the things. Yes, matters. No matters. Boiling water for the cleaning of the skin of goat matters. Goat छड़ी सफा कर रखते हैं सब माने गरम
water and water he post it and he died. That's what. Yes.
number of items no one items are placed with the complainant.
Yes.
More Sami Goro Sofa intermediate man উপস্থিত ଥିଲେ বড় অন্য সূচনা বড় পুস্তক ଥିଲା ସେମାନେ ଛେଳି ଦେହର ଚମଡ଼ା ସଫା କରିଥିଲେ ବଡ ଡେକିରେ ପାଣି ଗରମ କରୁଥିଲେ ଛେଳିକୁ କାଟି ତା ଦେହ ଗରମ କରି ପାଣିରେ ଚମଡ଼ା ସଫା କରିଥିଲେ ତିନୋଟି ଛେଳିକୁ କାଟି ତାର ଲୋମ ସଫା 2 ଘଣ୍ଟା ହୋଇଯାଇଥିଲା ଆଉ ତିନୋଟି ଛେଳି କାଟିବା ବାକି ସେଠାରେ ବଡ ପୁସ୍ତକ କଥା ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ମଦ ନିଶାରେ ଅଯଥା ସମସ୍ତ ଗାଳି ବିରୋଧ କରିଥିଲେ ଏହି ସମୟରେ ମୋ ସ୍ୱାମୀ ବରୁଣ ପଟ୍ଟନାୟକ ପୁତୁରା ବଳବନ୍ତ କାହାକୁ ଅଯଥାରେ ପାଠତୁଣ୍ଡ କରିଛନ୍ତି ବୋଲି କହିଲେ ଏବଂ ଏପରି ପାର୍ଟି ନ କରିବାକୁ ମନା କରିଥିଲେ କିନ୍ତୁ ପୁତୁରା ବଳବନ୍ତ ପଟ୍ଟନାୟକ ମୋ ସ୍ୱାମୀକୁ ରାଗି ଯାଇ ଅଛୁଲା ଭାଷାରେ ଗାଳିରେ ବିଦାୟ ଚପୁଟା ମାରି ଜୋରରେ ଠେଲିଦେଲା ଫଳରେ ମୋ ସ୍ୱାମୀ ବରୁଣ ପ୍ରସାଦ ଉପରେ ବସିଥିବା ଗରମ ପାଣିରେ ପଡ଼ିଗଲେ।
What is this? What is this of this? Is of the trial? 31st. Yes. Let this witness be after eyewitness examined. Yes.
It's costed since 10.
Eyewitness.
36.
Eyewitness. Yes.
Yes, sir. Liable this case. No,
immediately after I'm giving a direction to examine the eyewitness immediately. Eyewitness, we can yes. 6 months. Yes.
Material witness.
Yes.
The petitioner before Lordship is suffering from deep vein thrombosis. Your Lordship.
The health condition verified.
Yes, everything verified.
Yes.
He jaina.
That is a very problem.
Sorry?
Very problem.
Okay.
And our report here from the medical officer, the jail superintendent here, at present, he asked of the general symptomatic examination are normal and taking medicine regularly as per the advice. And we also image similar And the parliamentary category certain million. He is working for his for the operation. If not so direct million, after the also he may be operated million. Parliamentary category.
Yes. The prisoner is the collar dropper test and now waiting for Asian Medical College for test is free and no 5 to 6 months as reported in the daily also and therefore when the operation is fixed.
No, he said he start after 2 months he start will come here. He might have direct within a month then operation is million.
No, I can't directly ACB to operate.
No, he said that he term will come here, so many persons are there in the 2 million.
Whenever your term come, I will grant the.
Your Lordship, I am having a dying man in hand. There is no fancy in going in interim bail for a patient, my lord, who is there in March, since March. Now, their reports, I don't know what the jail superintendent is saying, but his condition is very serious.
Yes.
And first, let me address your Lordship on Doppler test. I am holding a newspaper, my lord, Doppler test में 5 मास अपेक्षा तेरी सब धरची में उड़े Doppler test ही है कि
charge and what are the offences?
Offences are allegation that I along with others have cheated the bank or the state about 3 crores rupees.
Charge has been filed. Charge has been filed. Charge has been filed, madam. When have you filed? July 24. Okay. Charge is filed.
3 videos have been suspended because their accounts is there's a compromise in connivance with some people. See video blog development.
We are giving 35% fixed loan to the tune 3 crores 70 lakh. What happened here? In the government, we are allocated that money from the government.
So anyway, she health condition of his wife, mother.
Mine,
No, one minute. What I do is I'll grant him 2 months interim bail, but regular bail I'm rejecting. No, I'll reject. You take it. Regular bail I have to reject because your bail fee was rejected on 14/5/2024. Thereafter, the preliminary charge sheet is filed on 2nd July 2024.
they are involved by the atheist court.
You renew it in the trial court.
I have filed Gurchi.
I am allowed because of the health condition. Why are you waiting for the HCB medical college? Go somewhere and go, sir.
What is your
You go, it will take 5 months, doesn't mean that 5 months I'll give you bail. I'm giving you bail for 2 months.
Yes.
You get it operated anywhere. And if I don't go, saying that I have to wait. So I won't do that. No, I'm going to give you 2 months bail. You get the operated. Regular bail application I'm rejecting. Because investigation is still going on. Preliminary charge sheet is filed.
That will also may observe.
Yes, sir. Right on. Petitioner is agreed by the order dated 14/5/2024. After the preliminary charge sheet in the present case has been filed on 2/7/2024 and the investigation is still going on. The allegation against the petitioner are serious in nature, and since the investigation is still going on, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the final charge sheet is filed. At this stage, Mr. Santanu Shadungi, learned counsel for the petitioner, submits that he has moved an application for entering bail on the ground of his severe health condition. The verification of the health condition has been done through the IO of the present case. She has submitted a report. She has submitted report entry. Submitted report dated 14/2024 entry लिया stating as under. Agenda 884. regarding to the aforementioned report and the documents submitted with submitted along with the application, I am up for the considered review that the petitioner is required immediate medical attention. Therefore, I am inclined to enlarge the petitioner for interim bail for 2 months, so as to get so that the petitioner can operate. You will have an operation. You will have an operation.
My lord.
So that the petitioner would get medical attention and, if required, undergo the procedure within the sale period. The petitioner is directed to surrender surrender immediately after the expiry of the 2 months period, and 2 months period, and thereafter, and only thereafter he can renew his bail plea before the trial court.
Here I have got a statement to make, my lord. I have contacted my relations who contacted Adorn Aesthetic Private Limited at Ahmedabad. I have indicated that in the petition. Maybe I require 10 weeks time if I go there.
No, 2 months time. You just I don't know. 2 months. Then you application.
Looking at the situation, if at all I go for a.
At this stage, I am giving this one.
2 months from the date of release.
And you submit the passport. Right down. The
passport.
Petitioner he shall be released on bail for 2 months on the to the satisfaction of the trial court with the condition deemed fit and proper, with additional condition that he shall cooperate with the investigation and shall not travel beyond the jurisdiction without the permission of IU, and also surrender the passport.
Beyond jurisdiction
without permission of the IU. You have to tell the IU you are going somewhere. I will inform that without informing the IU. Yes. Wherever you are going, if you are going and you will inform the IU saying that I am going somewhere. Yes.
I am going to take a number.
Yes.
Sir, from the date of release.
No, date of it. Obviously, date of it. Yes.
Yes. I
am the informant. This is my lordship. Yes, in the case of elopement lordship. Initial appraisal laws against the petitioner 363, and thereafter the subsequent on 362N. Yes. And 164. Read 164, sir.
These are 3 cases. In fact,
I'm appearing.
Yes. Yes. Also, 164 statement I filed 2024. Yes.
And in the meantime, victim examines who does not support the prosecution case. That is Miller annexure 2, running page 16 Miller, examination cross Miller, paragraph Miller 7 and 8. My family members had no willingness for my marriage with A1 petitioner. Although I was in love relationship with A1 and I wanted to marry him. There was no relationship. Where are you reading? Miller page 16, annexure 2, paragraph 7 and 8.
7 and 8.
Examination.
My family members had no willingness.
Yes.
A1.
And I wanted to marry. There was no relationship between myself and A1 during the period of my stay with him after my leaving my house till police brought me to Narayanapatna.
Yes. Madam, petitioner is accused and so on, so on. Okay. The victim girl has been examined as PW. As PW?
As PW Miller 2.
PW 2. It's not visible at all. What you would do? PW certified. In her cross examination.
In applying for the reprimand, notice already served, in the absence, council applied for the petitions 3. Applied for 2 times served. One of the council already appeared.
2 times Miller notice served on 25/6/2024 20/9/2024 ଯେହେତୁ ତାଙ୍କର କମ୍ପ୍ରମାଇଜ ହେଇଗଲେ ଝିଅ ସପୋର୍ଟ କରୁନି ହୋଷ୍ଟାଇଲ ହେଇଛନ୍ତି ସେଥିପାଇଁ
Despite notice correct, despite notice on informant oblique the victim, non-APS for the non-APS. The petitioner is accused on so and so, so and so, allegation is placed on so. The victim girl has been examined in prosecution as PW1. She in her statement has stated as under page 16, para number 7 and 8. 7 and 8. The petitioner is 24 years of age, whereas
no instruction regarding service of notice. Service of notice ଟା ସବସିଡି ଆମର କିଛି ନାହିଁ instruction.
service ହେଇଗଲା ପରା କହୁଛନ୍ତି ଆପଣ
ନାଇଁ ସବସିଡି ହେଇଛି ନାହିଁ.
just check it up. It tells us that is very important.
373 for that.
You said somebody.
এটা ହେଇଥିବ ଦରକାର ନା.
state କହିବନି extra copy 2 times Miller I served on 25/6/2024
You said service is complete, I have recorded. You must tell me, huh? That is not complete. Bill can't be given right like this. Service on opposite party number, service on the informant of the victim has not yet been completed. The petitioner, counsel for the petitioner is directed to take steps to serve. And IIC of so and so police station is also directed to serve the informant of the victim. Next.
Correction of constating matter. In place of Naik, it has been typed as, in place of Pai, it has been typed as Naik. Husband of the name of the husband of the petitioner.
What do you want to say? I am not followed what.
Correction of the constating matter. Name of title of the husband. In place of Pai, it has been mentioned Naik. Can I have a glass of constating matter? Pai.
It has been
Pai का जगह है.
Pai की जगह नहीं की जाएगी. अरे सी on 28/9/2024 ऑर्डर से Pai की जगह नहीं की जाएगी. देखिए, हाँ चेंज कर, ठीक है? Okay.
So that matter where he was called as a witness, summons were issued to him. It was alleged that he is in Dubai. And thereafter, when he came back on a lookout notice, he was brought here. Under the PML Act, Mr. Agarwal was. He's on bail in the scheduled offence.
Then just pass it over. Let Mr. Agarwal come.
Yes.
After lunch. After lunch. How many matters? I intended to pass over it. It will take the time.
2 o'clock?
Pass over or put it some other day? What do you want?
Here, my senior friend has filed an application for interim bail.
That we are not present.
If that is not present, then your lordship may post it to the date sheet because that.
Why for interim bail you sought for?
He was suffering from chest pain, your lordship.
Now it's all.
Now it's okay, your lordship. That is fine.
The matter was posted on 25th. I have to take instruction.
No, it was posted on the court. It was said that it will come on 1. But as your lordship was not there, the matter got posted. In the meantime, he was having some health problems. So for that reason, he filed your lordship.
No health problem, Earlier also you filed an application in.
He is not pressing what should you.
No, that's what my friend is saying. Because of health problem, they filed application. All are false statements, Earlier also similar application was filed, rejected, posted for hearing of bail application. When this matter was posted on 25th, they to prepone the date they filed the interim application on went around on false grounds, You are application on the health ground, report was called for, we have no medical problem,
Unless,
That's right.
unless I lecture on 25th October.
Because
Lecture on 25th October. Since you are not basically it will come 25th. In which 25th October, the interim bill application is not pressed. Because the date already fixed. Already fixed on 25th.
Instruction.
Why should we? Yes.
Because actually we only to get instructions in the entire matter.
When we get it on, by that time you get the instruction.
yes,
Because the date already fixed. Interim order not paid.
This be given as a last chance, Malad, because
All right. Mr. Agarwal submits that the matter is already adjourned to 25th October, and by that time he will seek instruction and address the court on merits of the case. Yes. 25th. Okay.
Malad.
Obliged. Because when the turn comes,
They don't do it. My only prayer, since I argued about 2 months back, to be fixed, delete my case and the other two may take their own course.
that when no, because there has to be one judgment. One judgment I want to call. That will create problems.
My case is
I understand.
from the other.
Anyway, your case is relevant. You proved relevant,
Yes.
according to you. And what about the other people? I don't know. Let's see when time comes.
And notes are also ready.
Yes.
It's a plan. Yes. It doesn't specifically fix that root claim. So let him call this matter after vacation.
You are appealing?
Yes. He is appealing.
I am also appealing for that.
What do you say? Why don't you argue and finish it up? At least you do your part, and he is seeking adjournment. I'll put it
Post vacations.
post vacation only. If you want to address, you address.
That my letter we should submit is short or submission is there.
That's the problem.
Also want after vacation minutes.
Only evidence of 2
3 o'clock immediately after vacation. Good.
After vacation, yes.
week after that.
24th at 3 o'clock. Don't seek adjournment because see, the hearing which has already taken place will go away. It's a parted matter. 24th at 3 o'clock. It's made clear that no further adjournment.
Yes. Great.
You also get ready.
Yes, I will. Yes.
Yes.
Your lordship fixed to 24th.
24th. Yes.
Let it come on 25th, my person.
Okay.
It's a Friday, not Friday. Friday, na kya ho?
No, that will be 24th only. Yes. Next.
41.
With his lordship.
Yes.
24th.
Yes, madam.
With his lordships. The petitioner is in custody since 30th of August 2023
Yes.
and has been charge sheeted under section 376(2)(f), 376(3), your lordships, and 6 of the postcode. I have given the depositions also with that flag A, your lordships.
Yes.
The
So the victim deposition.
lordships. The victim, your lordship, is PW1.
PW1. Huh?
Lordships.
Yes.
She has supported, but there is a little bit of discrepancies there. It is stated that the alleged incident took place about 7 months back in the FIR.
Yes.
Your lordship will see, but when it comes to the deposition, she says no, it is just 2 months back. She says that she's the incident that came to light when the minor girl was taken to the hospital where she was found to be 7 months pregnant.
Another thing, my lord. Is 3 there, my lord.
Notices.
Notice has already, my lord, sent to the IO, my lord. But in fact, my lord, receipt has not come.
Okay.
Twice
I contacted the IO. Yes.
Notice on informant of the victim is awaited. Leads the matter after vacation. Yes. Yes.
My lord.
May I please, your lordship? I want VC, my lord.
Yes.
My lord, the FIR was against unknown persons. This petition were custody since 27/4/24.
27?
4/24.
Yes.
allegation is, my lord, while the police personnel were during anti-nuptial search, my lord, they found some IED inside the jungle. Subsequently, they have recovered it and diffused those articles. During confidential inquiry, my lord, they came to know that these petitioner providing food and water to the Naxalites. For that reason, my lord, they have this petitioner.
My lord,
He has no.
That is not yet been filed. That case diary I have received, my lord, the office received on 3/5/20 up to 3/5/25, my lord. 24, my lord.
No, Mr.
Thereafter, no case diary was received.
He submits that up to date, he has not received up to date case diary. Hence he seeks a week's time and leaves the matter after vacation. Yes.
My lord, last occasion also they have taken time on this ground, my lord.
One more opportunity. Yes.
What is the date?
May I please your lordship?
Yes.
May I please your lordship? I am appearing through virtual mode from Thamalpur, and the case is under section 302.
Yes.
And the petitioner in custody is 17/11/2022.
Okay.
Sir, on 27/9/2024, Land and State Council has taken time for verification of the deposition. In this case, the total case is stand on the statement of one Prakash Behra and Anil Sahu, who were the eyewitness of this occurrence.
They were examined.
The Prakash Behra has examined as PW8 and Anil Sahu has examined as PW3. The statement of the Prakash Behra is in running page number 68.
He made solve the deposition copy, my lord, so that
Deposition copy. You have not given deposition copy.
I have already filed, madam. Filed, sir, deposition copy.
Some more evidences are there, my lord.
As far as out of 30 witnesses, 15 witnesses were already been examined, and most of the witnesses turned hostile, not supported the prosecution, sir. And the eyewitness also not supported the prosecution.
Yes. Who is the eyewitness? PW1 or
PW8 and PW13 are the eyewitness.
PW8 and 13. PW8.
What happened in this case, my lord?
Yes.
Well, the bail application was rejected, my lord. By the time the eyewitness have not been examined, my lord. Bail application rejected on 26/4/2024, my lord. But the eyewitnesses, the witnesses later on examined, my lord. 13/5/2024, my lord.
13/5.
13/5/24, my lord. And 113/5, then my lord, another is 29/5. After that, my lord, you may remove there, my lord. And 29/5.
Yes.
Other witness matter to say examined after that, my lord.
See, the eyewitnesses are examined after your bill application was rejected. You remove the bill. Petitioner is agreed by the.
Sir, because the eyewitnesses were not supported the prosecution.
You will get bail.
Your Honor, your Lordship may kindly peruse the statement of the PW8.
I have 26/4/2024, whereby his bail plea has been rejected. Subsequent thereto, the material witnesses and the eyewitnesses have been examined by the prosecution. In the changing circumstances, petitioners may renew the bail plea before the trial court. If such bail plea is moved, then shall be considered on the basis of the evidence available on record. With this observation, petition is disposed of. Yes. Next.
44.
Yeah, please, your lordship.
Yes.
The matter petition initially custody matter 2022. 2022.
Yes.
Approval 22C of Indigenous Act matter.
Yes.
And the petition is the driver from the vehicle number 130 of Ganga has been seized.
That's a lot of number.
Up to date, my dear tester.
Up to date is not received. Yes.
45.
Public.
45 initially 457,380, and subsequently charge sheet submitted 395. Allegation is that office ଭିତରେ ପଛିକି 4ଟା CCTV ଆଉ 2ଟା କମ୍ପ୍ୟୁଟର ନେଇଗଲେ ଅନଲାଇନ ଲୋକ। ଏହା ହଉଛି allegation। ତ ରହିଲା ରହିଲା କାଶ୍ମୀର ଆଉ 27/3/2024 6 ମାସରୁ ଉର୍ଦ୍ଧ୍ୱ ରହିଲାଣି ଚାର୍ଜସିଟ୍ ହୋଇଗଲାଣି।
Charge file on?
ଚାର୍ଜସିଟ୍ ଏଠି ଅଛି।
You file on
Charge file on 25/7/2024. 25/7/2024.
25/7/2024
Antecedents?
Antecedent 2ଟା ଅଛି। ଆଚ୍ଛା antecedent ନଥିଲେ ଏ କେସ୍ ହବ କେବେ? ମୋର ଗୁଡାକ ଆଉ କଣ ତାକୁ ରଖିକି ଭିତରେ କରିବେ?
Let them stay sometime.
6 ମାସ ରହିଲେଣି।
What is the position in the other two cases? What are the recoveries? Recovery ମାନେ ଗ୍ରିଲ ଭାଙ୍ଗିକି ସେମାନେ ବହୁତ ଟଙ୍କା ସୁନା ରୂପା ଚୋରି କରି ନେଇଥିଲେ। ନଭେମ୍ବର ମାସରେ କୁଆଖିଆ ଅଞ୍ଚଳରେ ଭାରେଙ୍ଗାର
ସେଇଟା ଅଲଗା କେସ୍। ଏଇଟା ଏଇ କେସ୍ କଥା। ଏଇ କେସରେ ଚାର୍ଜସିଟ୍ ଲେଖା ହେଇଛି।
Yes. Articles, stolen articles and seized two printers from the Samir Kumar Das, CCTV camera from Sateshwar Behra, and 2 desk. Maheshwar Padiari. Record my lord. Maheshwar Padiari, Samir Kumar Behra, Mithun, and Maheshwar Padiari, nothing my lord. Nothing is recovered.
ये वाला अमीन मुंडा आ गया।
you Maheshwar Padiari. Amina Munda.
ये अमीन मुंडा आ गया।
एक मिनट। It's an Amina Munda. Amina Munda.
45 minutes.
Amina Munda will CCTV. एक मिनट। 2 CCTV camera from Amina Munda. From there, possession and what bail application number?
Bail application number 6894.
6849 scan correction भैया। Amina Munda recovery 6894. And when it is just see. No, some other files is scanned. Some other file is scanned. It's 6849 is scanned. After vacation. Okay. Scan properly करो भाई। अमीन मुंडा फाइल रे भर्ती महेश्वर something महेश्वर पडियारी। हाँ। 6849 that scan.
But my number is 6894.
9449 कर दूँगा। मंगलपुर केस का नंबर 120। हाँ ये this is somewhere else. Yes. Yes. After vacation. Yes.
Possibly fixed.
After vacation. Yes. 46. Service.
Not taken it. Steps regarding service.
You have not taken steps.
46.
On the opposite party number 2, the counsel the petition 6 adjournment. Please the matter. Number class. Number class. Yes.
47.
Yes. 47. 2016 matter. And then a piece of petitioner. For the anything not of us earlier.
Notice also. 47 notice also.
Notice?
Steps of issuance of notice and admission matter of 22 has not been taken.
Question has not been taken. This matter is pending since 2016. An interim order has been operating and it will matter since 28/6/2018. the petitioner has not taken steps for servicing notice, has not been taken till date. In view thereof, it seems the petitioner is not interested to prosecute the case according to the petition discussed. Yes.
48.
48. Non-appeals for the petitioner in the interest of justice, adjourned to December. Yes. Huh? And even the defect pointed out by the registry has not been cured in the interest of justice, adjourned to December. Yes.
51.
Service. 51.
No proof of service. No proof of service.
Proof of the service and the opposite party is awaited, non-appeals for the petitioner in the interest of justice, adjourned to December. December last service.
May I lordship? That matter is urgent to today, your lordship, on Friday.
Yes.
311 petition has been rejected and lordships inclined to 311 petition has been rejected. Lordships. Lordships last occasion lordships inclined to allow the petition, but lordships Vigilance Council has not been solved the copy. I have already solved the copy.
Yeah, yes. Who is appealing in this matter? From or may not be possible. Yes, I'll put it immediately after vacation. Huh? Immediately after. Okay. Immediately after. Yes. Yes.
I will pardon me. Just at the 51 minute.
Permission is not complete.
I will
Permission is not complete.
Then may I pay? Because the court is insisting for the trial. Some may permit me to, if I file application for adjournment, that will be considered.
No, what is this matter?
The matter is not says law. Initially says law.
Process fee and everything is filed. You see, everything is filed.
She is appeared. She is appeared earlier.
In the meantime, Mr. Chand submits that he would move appropriate application before the court for seeking an adjournment.
Actually, what happened in this case, my lord? They filed the application for recall of the victim. Victim, victim and her mother, my lord. After their exemption, matter has been solved. Marriage has been solved. Examined in the court. They have not.
My friend is right.
I understood it. Thereafter, they will clear the level.
My lord.
Yes, he will reject it.
My lord. And marriage will be not big.
Let that be stay. Let them stay peacefully for some time. We'll see. And December review.
I get it.
And if something happens, then come and oppose. Otherwise, they will.
If application will file, that will liberate.
Yes.
Hello.
Yes.
3 months. The interim mediation report is at flat B. The lordship has sent the matter for mediation.
Interim mediation.
That is what it is marked in the notice.
Why interim final mediation? What happened?
That's not
or not.
I'm for the opposite party. I have already entered appearance in the mediation center and date has further date has been fixed on 25/12.
Oh, well, release it after. Mediation is still going on in this matter. Just release the matter after November.
First week of November.
Yes.
54.
No stage there. After vacation? Okay, after vacation. Yes.
55.
Yes. Service to proceeding. And at least for the petitioner in the interest of justice, November. Yes.
56.
56 million as per laptop notice has been served of OP number 2.
Pursuant to the order dated 24/9/2024, notice on the opposite party number 2 has been served through the IAC Kendrapada Town Police, but none appears, none entered appearance for opposite party number 2, even the none appears for the petitioner. When the matter is called, hence the interception schedule. Yes. December.
59.
It's a vigilance criminal appeal matters after conviction of 2 years and fine of rupees 1,000. Admits bail granted. It is already, Your Lordship has already admitted it, and TRC trial court record has not done. I have filed an IA for stay of conviction. I know, my Lord's, Your Lordship's view on this matter, but what Lordship may kindly appreciate, I have tried to find out. Lordship may kindly appreciate my small research, where this is a special, where my Lord's lost better you research of the main matter. Yes, sir, that's correct. What is the difficulty? Well, by the time the main matter will be heard by Your Lordship, I'm sure you will be abroad. Yes, my Lord, that is very difficult. And my Lord, I found that losing job is not an exceptional subject to the condition. That is what I very narrow. Once you are convicted, the presumption of innocence goes. That's correct, madam. And for renewal of service, conviction is not required. Yes, madam. Any act leading to conviction is enough for the purpose of renewal functions. But is it necessary? You should be convicted. Well, that's any conduct of an officer leading to conviction is enough for renewing. No, it's absolutely correct. Well, here is a case. Well, I'll submit just 2 lines. Subject to Your Lordship acceptance. If Your Lordship permits me. Yes, tell me. Here, this conviction, Your Lordship, whatever. Do you have any judgment? Yes, madam. Yes, madam. Don't show an objection, Sidhu. No, I'm not showing objection, Sidhu. If Your Lordship permits me, Malats, beyond objection, Sidhu show me anything. Lordship knows that Delhi High Court in Delhi Price case, Malats, don't show those things. And then Malats, then one judgment of 2007, Malats, Rabi Khan, if Your Lordship may kindly have that. Yes, which paragraph? Lordship may kindly come to 12.5. 12.5. Yes, ma'am. By placement, yes. All these decisions, while recognizing the power to stay conviction, have cautioned and clarified that such power should be exercised only in exceptional circumstances. Where? What is the exception circumstance? Yes, that's why I lose my job. That is the exception. No, losing job is one job. Something. No, that's correct. Here, Malas, I'm just trying to make it. That is the exceptional circumstances in every case. I have to stay then. Everybody is going to lose the job. Malats, may I submit one more thing, Malats? Your Lordship is absolutely correct. Malats, in 2014, Hon'Ble Apex Court said that losing the job vis-a-vis other factors. That needs to be weighed, man. Lordship, that is how. Well, I am not just in this case, then I have to pass. But here, if your Lordship, here is a case where you concentrate on merit and argue. On merit also, but so far as having a prima facie case, here, Malats, the demand is not proved, the receipt is not, then you will be, why will you concentrate there? Well, that's correct. Well, by the time Your Lordship will hear, I will be using my. I am putting it for hearing. Just giving the supplementary and hearing. I will Lordship, please. Yes. Another thing, subject to Your Lordship. Yes. Losing the job is absolutely not exceptional circumstance. Subject to the condition, it is at the cost of the gravity of the offence. Here it is only 500 rupees and the demand is not proved. The recovery is not from me, and peculiarly the person from whom money was recovered has not been known and accused, not been a witness. So therefore, well, that's what my humble submission. I argue. Get ready. Yes, immediately after the case at 3 o'clock, keep it. And he has, since he has research. Yes, ma'am. Yeah, in the case of acquittal, why are you wasting time? Argument and finish it, I'm grateful. Yes, ma'am. Give a copy and TCR is already there. Note, TCR has come. Let's see. No, it's noting says it has not.
This is noting.
Call for the TCR. This is the matter for final disposal on 29 at 3 o'clock. In the meantime, let counsel for the petitioner to prepare a paper book and supply the same to the opposite side. Opposite. Three papers you prepare. Yes. In the pen drive you take everything and prepare. Yes, please. I'm grateful. Ready. Grateful. Yes.
Item 60.
Formatted to withdraw. Very good. Obliged.
61.
Yes, sir.
Instruction. What is the case, my lord? Yes, is my lord, the petitioner are to.
Where is the direction? Where is the direction?
Order to await to open instruction.
Which order?
Voting the achieve regarding instruction to the statement.
Which one? Tell me the order. There is no order for instruction.
No, that is.
It is only interim order is taken. Adjourn.
Whatever, my lord, in this case, there is a this petitioner, there's two petitioners. One is my lord, doctor, another is a professor. They are the society's president and secretary. They dispute arrangement when they are allotted the entire area, they are given duplex. And allegation FIR was registered against the builder for making for electricity.
Illegally used to.
FIR for occupancy, FIR against the builder. Subsequently, he manipulated case of charge sheet against president secretary.
Not connection mandate, I have instruction. That regarding the name of the builder minor, the instruction is there, that the BD case number 1082013, it is ascertained that the builder, namely Piyush Mahanti, has been exonerated from the charge against whom the affair initially initiated. Besides, no other investigation is pending against the above named.
That instruction was given because pursuant to the direction of the Chief Justice Court, there is a direction for registration of the case against them regarding the matter. So that is why there is an instruction regarding whether here these petitioners, they are the society's president, secretary.
Let us come to the allegation.
My lord. Running page 9 FIR, small FIR, my lord.
Charge sheet you show me. You are challenging cognizance order with FIR. Show me the charge sheet.
Charge sheet.
You are challenging cognizance order without charge sheet.
Charge sheet, I have the copy, but visible setting I couldn't find.
Very answer 2016 matter. Without filing the charge sheet, challenging cognizance order. And we want to
charge sheet is
this is unheard of.
It's copy
2016 you took of cognizance order without filing charge sheet. And seeking adjournment.
Where
interim order to continue. Interim order to continue.
I want to project.
I'll make it the file.
I'm ready to matter, madam. Okay, the charge sheet will give you, madam.
If the court is not entitled to see charge sheet.
Certain
in an order where the cognizance is challenged. Cognizance is taken on the FIR or charge sheet? You tell me. Cognizance is taken on the FIR or charge sheet?
After submission of charge sheet.
Then
after submission of charge sheet,
on 2016, no, you should minimum.
Yes, minimum.
You just place it on record and immediately after vacation. Then counsel for the petitioner seeks to file the copy of charge sheet. Dating to so by tomorrow. By tomorrow, use the matter. And immediately after vacation. Entry want to continue. I'll give the advance copy to him also. And give a copy, then again he will ask for adjournment. These are very old matters. Why does
they matter be disposed of?
Yes.
62.
62. Yes, madam.
In the last occasion in CRMC number 464 of 2016, the lecturer appointed my senior. However, we have not been able to establish contact with the informant in this case. therefore couldn't file the vacant.
No, here also from 2016, what is continuing?
Not the claim for the petitioner. The court had appointed Mr. Jema as the counsel for the informant.
Court is appointed.
Yes, Your Lordship. But however, we couldn't establish contact with.
Where is the father?
Lordship, I couldn't find it online.
Annex 7, page, internal page 8, my lord.
7.
My lord.
Yes.
That is the order, 1CC case order.
Yes. Yes.
My lord, the para.
No, what is the challenge?
My lord, challenges the cognizance. 24/7/2015.
Okay.
The section 498, 304B, 302, 406, and 4DP.
Yes.
That stay order was, my lord, it was vacated by the court below, basing upon that SN it is facing.
Yes.
Then after it is pending, my lord.
I mean, stay is vacated.
Stage, my lord, can you see that order? Page 8, my lord.
Page 8 of what?
Well, page 8 of Annex 7, that is the rejection. 1CC case order was passed by the court, madam. Let's have got it.
This is item number
62.
62.
264 of 16.
Sushant Kumar Mishra.
Sushant Kumar Mishra, yes, madam.
The order that you know, page 7, I don't know.
Page 8, 27/8/2021. Or
no, it's something else. Now, in second matter you might be referring to. Second matter. 1 minute. Yes. All are FIR.
In second matter, there has not annexed all this.
Which one we are referring to?
And this is the, well, it was annexed here.
But the first annexure is the FIR. Start from page 14. Petition is still page 13.
Well, this is the order which he has given us. That. And second para, that page. Order dated. I have underlined this.
And now what happened thereafter?
So stay has already been vacated. So till now, which is only Arjun was made, my lord, from time to time.
Stay vacated 2021. What is the status now?
The status is this matter is only Arjuning from time to time.
But what is happening there?
My lord, he has to take instruction what was happening.
Lordship, I beg your pardon. I am not for the petitioner.
I understand it. Even if you are for opposite party, you must know what has happened.
Lordship, in the last occasion, the court had appointed Mr. Chinna. However, we have not been able to establish contact. This may come after vacation. We'll file a vakalat during the time.
No, Mr. UC Jana was the petitioner.
Right. Second. The pending matter is pending since 2016. On 16 to 2016, an interim order staying the proceeding in ICC case number 286 of 2014 was passed. 14 was passed. However, on 27/8/2021, declared that JMFC has vacated the stay order passed by this court in accordance with the judgment of Asian Reach Application performed. Thereafter, what is this? Thereafter, the status of the case is not known to the parties. To ascertain the status of the case, is the matter answered.
Yeah, actually, copy me these.
Copy? Who will you? I will you copy.
It is
clear that on the next date of hearing, if non-appeals for the petitioner, the matter will be dealt with in his absence. Yes.
Okay.
In his absence, all the things will be after. Stay in charge.
Last occasion, the Senate could issue notice to the appeal number 2 matter.
What happened? Last occasion? No.
20 matter.
Ask notice also
29/2022 matter. Thereafter, the matter was dismissed
due to miscommunication.
Is further not.
No, if you are already issued.
Huh? Service.
Huh? Notice already issued, madam. Transparent matter notice. 29/2022, madam.
Huh? Service on opposite party number 2 has been incomplete. However, none appeals for the opposite party number 2. The opposite party number 2 moves the matter for hearing next. Yes. 64, yes. 64. Again. What's this matter?
Number 64 cognizance. That is order dated 1/2/2016. Under section 341, 323, 294, 354.
None appears. Stay order operating since?
Past orders is reflected on 28/10/2022. The non-appearance of the petitioner report.
The non-appeals of the petitioner. The matter is pending since 2016. The order, the interim stay of the proceeding, further proceeding in GR case number 590 of 2015 pending in the court of order in SDGM bracket S Cuttack. It's stayed by the order dated 18/5/2016. On the earlier occasion, petitioner has been seeking amendment time to time. In the interest of justice, by a last opportunity, let's release the matter immediately after the case. First day, second day, we will dismiss on the one opportunity. Yes.
65.
65, my lord, my lordship.
Yes.
My lord, here is the case, my lord.
Sorry?
Here is the case, my lord. My lord, it's a complaint case. And the present petitioner filed this authority to approve for crossing of the proceeding. On the ground, my lord, the marriage solemnized in the year of 2005. And both the parties enter into an agreement. Both are relative. Both are relative. The petitioner and the appeal number 2, both are relative, and there was a marriage. And 2008, both are separate. 2008. Thereafter, the present petitioner remarried in the year of 2009. 2009, the present petitioner remarriage. The present petitioners, after the agreement by 2008, thereafter the petitioner got married.
Yes.
Thereafter, my lord, in the year of 2013, the appeal to file a complaint case. The lordship can receive the complaint case.
And cognizance of which has been taken.
My lord, yes. My lord, here is the lordship kindly, my lord, acid page 9.
9, okay.
It is also pertinent to mention here that the accused persons manipulated to obtain her signature in stamp papers and managed to get a registered deed of divorce on 5/12/2005. How can a divorce be granted by registered? No, lordship is, my lord, in that line, my lord, I will show a decision. It's, my lord, illegal. It's illegal. It's illegal, my lord. Your lordship, it is not permitted. My lord, I admit your lordship, so in that line, I will show, my lord, one.
You are relying upon that divorce petition?
No, lordship, what happened here? My lord, the appeal number to file the 1cc case. My lord,
you simply tell me whether you are obtaining this registered deed yourself or not.
Both are admitted. Both are admitted.
How can you annul the marriage? That is
the facts. That is the fact. Thereafter, your lordship kindly turn to annexure 3. Annexure 3, my lord. The present petitioners, my lord, according to the, my lord, filed a divorce case and divorce was allowed for it. 2011. In 2015, divorce was allowed, and thereafter the present number 2 filed, my lord, appeal against the appeal. But they are not working. My submission is for lawsuits. Yes. The lordship kindly see. Yes. The appeal allowed this was up. The lordship kindly see the judgment and the appeal. In that line, my submissions, in that line, the Honorable Supreme Court, in a decision decided in Sojana question, case decided in 2008, the action can be seen. The High Court allowed the proceeding. Yes. The section 495, 495, from the classical,
come to the issue. Which paragraph?
Last paragraph, but no allegation has been made out in regard to the commission of offence, so the offence is responding to and through concerned. If even for the exercise of jurisdiction under 402, the criminal procedure, the High Court has taken into custody admitted document. We do not see any illegal information therein. I can allow the proceeding under the illegal well, actually, can be seen. The customary business may be legal or illegal. It's not a question. It is no lordships. Both are relative. My submissions before lordships, both are relative. There are no Mamura
not object to it, I will quote it.
You know, permanent alimony already subsequent event.
But that is subsequent event.
Permanent alimony as per this Honorable Court, you will actually can see
that will not violate the offence which you have committed.
No, lordships. Here is the case, my lord. Both are separate since 2008. My visualization case. I am not standing on your lordship's way. I am trying to convince.
I have already convinced.
Your lordship kindly see again. I am reading.
Can I tell you the facts now?
Hello.
Fact is, you married to this girl and prepare a registered sale deed of divorce.
Registered, that is the admitted.
Okay.
And that is my submission, my lord. Even if one registered document has been issued, my lord, civil court has power to decide whether it's a legal or illegal. My submission, that is the decision, my lord. I will option the. That is what do you want?
This is a matter of 2016. 2016. My lord, I have to take instruction regarding if she is ready. I don't have any problem, my lord. I have to take instruction from the.
You have now separated. You have taken alimony.
My lord.
And put an end to it if you want. If you want to insist, then he has to face it. That's the you are under her mercy. If she says yes, I'll cross it. If she wants to proceed, nobody can stop it.
So
immediately, second day of DOP. For sure, you have committed an offence and cognizance is taken. You may be acquitted, that's a different story altogether.
No, but you can't prepare a registered something. Registered, my lord, that is why, my lord, this unknown court said, legal.
But once registered, be positive that CB come and say that I am not prosecuted. 2016 matter, CB say that. Okay, please sit.
66.
Yes. You are correct. It's impractical. Prosecuting you will lead nowhere. You may be acquitted, but technically you have committed a crime. Yes, we'll see. Yes. 66.
Permitted to withdraw.
Okay. Withdraw. 61. Yes. Yes, 69.
Because 69 years, the person is the husband. Yes, the order date is 17/7/2013.
Yes.
Which cognizance was taken under section 492 and 34 IPC.
498 or 34 is.
Right.
Pending. None appears for the petitioner. Sir, I should give one opportunity, isn't it? This matter is pending since 2016. There is no entry order.
23/16 stay of proceeding is there.
23/8/2016. 23/8/2016. Stay of stay of further proceeding in GR case number 411 of 2023 pending in the Court of CGM. Sadari Patak is operating since 23/8/2016. None appears for the petitioner. In the interest of justice, last opportunity is granted to the petitioner. Military matter. Again, same.
70.
The same case, my lord, where two of them were washed against me and the other two are there. None of them are appearing that.
No.
But their neighbors. There are 4 cases initiated. 2 against me, by me against them, and 2 against them against me. The 2 of us, all of us filed affidavits.
Yes. See, neighbor, there are 4 cases. 2 cases against each other. Otherwise, agreement. When it comes to
So both are neighbor. So you maintain the breach of peace and settle the matter out of the court. That proposal already I have given and in this already been settled. So I pray you will kindly next after vacation also then already have intimated the informant in this regard to file one affidavit matter. That is
well, they have already filed the affidavit.
That has been filed before the court below.
I will act upon the affidavit which you have filed.
Yes.
No, that has already been filed before the court below.
How does it matter?
So I pray vacation also they have
I'll record them you have already settled the dispute and you don't want to file affidavit.
No,
why unnecessary keeping pending all these matters? See, 2019 matters. See, the court is not under the mercy of litigant. You can't keep on waiting for your instruction.
Submission before the lawsuit, the petitioner, both the houses are adjacent to each other. Like the fact is that he has not given the permission.
Separately, the court can provide those cases which are in court also.
Exactly. See, they have gone to civil court. Injunction is there. And still, and both sides suits are pending.
Suits are pending.
Yes, suits are pending. But recently, one of those matters.
I am reserving judgment to bring the affidavit.
The annex of 3 is that was a compromise in another case. That is not Senior has filed. I am not disputing the fact. He has put his signature.
Both are signed. Joint affidavit.
But the fact is, it is
Where is joint affidavit?
Joint affidavit annex of 3, but not in this case, man.
No, not in this case. There are 4 cases. 2 against them. There is a compromise.
So in this case,
and on the basis of this agreement, the 2 cases which were filed by them against them has already been filed. And when it comes to
annex of
just the was there. Let me learn it. Matters have been paused. Not only 100 some odd, my lord. It's disgusting, my lord, that these matters should be.
I may leave my.
It's very unfortunate.
Saying that. Yes, ma'am.
I'll record this.
I'll file my affidavit.
There are 2 cases were filed by the opposite party number 2 against the petitioners. And petitioner had also filed 2 cases against the opposite party and other accusers. There is the parties are neighbors. Four parties are neighbors. Therefore, they settle on the basis of the settlement. The cases which were filed by the petitioner against the opposite party number 2 has already been quashed. On that basis, on the basis of the settlement and the same settlement, the petitioner seeks the quashing of the present proceeding. The matters are pending since 2019. The unconscionable of the opposite party submits that one last opportunity is granted to file an affidavit regarding the settlement. By way of last opportunity, this 1 week time is granted to the opposite party members to file the affidavit. This is the matter. On 25th, on 25th.
Well, I requested for stay of the proceedings while on. No, that has not been passed, madam.
And I'll pass it. In the meantime, proceeding before which court, which matter?
2457. I number 2457.
Only the particulars of
the court, yes.
Proceeding before
ICC case.
ICC case number?
SCST, not at special just SCST management.
ICC case number?
Case number 258 of
2016, pending before so state. Yes.
And my lord, my learned friend said that I may be permitted to file a perjury, madam.
No,
I file a perjury. Let him then suffer that, only then he will.
Who said that I am saying that this is a forgery? I have always.
Let's see, if you don't act in that number, I'm giving now to file it here and put it as a.
Said that. Yeah, why do
okay, don't waste time. Don't waste time, file it.
Sir.
Unnecessary, don't yes.
71.
71. Yes.
There's a case where the petitioner was the branch manager of HDFC Bank.
Takes some time. He has deliberately created that book so that we keep on adjourning and enjoy the entry model.
No, entry model is not there. In fact, my lord, what is happening, my lord, every time the lawyer on the other side changes, my lord, and this thing happens.
There is no entry model here.
No entry model. So
let us fix it.
You will actually fix a date. And one thing, my lord, let the file be with my learned senior, so that it once it changes, means the same.
I can't pass an injunction order against don't change the concept.
So, my lord, what I primarily will actually fix a date at 3 p.m. If you lordship could
fix a date.
Okay. Yes, immediately after vacation, my lord.
Yes, 72. Sir.
Yes. Page 31, if you see kindly.
Page 31.
Yes, page 31.
Yes, sir.
This is the FIR that has been given.
Yes.
FIR has been given by one person, that is Devajyoti Datta, at page 33.
Yes.
The candidate turn to page 65.
65.
Yes.
Yes. Yes, sir. 65. Yes.
At the second paragraph, last 4 lines.
Yes.
As the fraud amount involved was only 4 lakhs. Got it?
Much below the threshold limit of rupees 1 crore mandated for EOW. The matter was referred to DCP for registration of a case. However, the
so in the High Court with a prayer for order to register a case. Actually, initially it was not registered. Of EOW on the basis of the petition dated 8/17. The Honorable High Court, actually a batch of cases were listed, including this one. The Honorable High Court of Orissa passed order on 19/12/2000.
Narration case of EOW. And below threshold. 20%, 1 crore.
Right. But if you'll assume kindly
Yes, yes, Mr.
Miller, that is not a correct statement. Your Lordship, kindly 63. That's it has been submitted.
No, sir, he says that 4 lakhs only.
Miller, one person would be, your Lordship knows, a criminal motion can be moved by any person. One of the person who has been viewed, he moved the FIR, Miller. During the investigation, it has come to light that apart from him, other 3 persons amounting to rupees 40,71,888 were cheated also. 40,71,880.
That was a less than threshold.
Apart from 4 lakhs is the person who was first initiated the affair. Another 3 persons during the investigation comes that they have invested more than 40 lakhs.
40 lakhs.
So the investigation continued. That means prima facie, what has been divulged in the affair, it has a basis, Miller. Not that it was only out of blue.
Sir, page 73 का देखो.
But what he says that it should be EOW, it should be.
Your Lordship is considering.
No, page 73.
Let my Lord senior complete.
Yes, 73.
Page 73.
Okay.
EOW circular, 1 of 2012.
I've seen 1 crore and 20%.
So it clarified that racketing, fraud and investment, deposit, cheat fund, money circulation, fraud involves more than 20 victims.
Yes. That's what I'm saying.
We invested by
20 victims, 1 crore threshold.
So kindly have a look at another document, page 76.
26.
Yes.
Yes.
2016 notification is
amended.
Is amendment 2016 minute. Kindly turn to page 78.
Yes. By any financial establishment.
Deposit including deemed to always have input and receipt money, acceptance of the valuable commodities to be returned after the specified period. Then financial establishment which without benefit of function and so. Then clause 5, amount received in the ordinary course business by way of advance against order of goods of service. The next page, explanation. Any credit given by the seller to a buyer on the sale of the property whether movable or non shall not be deemed to be deposit for the purpose of and interestingly, if you also kindly see, the person who has lost an affair, he has filed an affidavit, page 68.
Yeah. 68. Yes.
Yeah, I am the petitioner in criminal case also. The Honorable High Court directed economic offence wing, Bhubaneswar to register a case on section 406, 420 and 6 OPID, corresponding to city case 2 of 19. I have deposited 4 lakhs only for a 3 BHK flat on this one, but due to unavoidable circumstances, Mr. Prabhat is unable to hand over the flat, also unable to refund.
And he got amicable settlement.
9.82 lakhs.
Out of 4 lakhs, he got this much.
9.2 lakhs. That has been paid. There was no other complaint. All the
he says that apart from Debussy, the other investors have also come.
But there was no complaint. Flats have been given and that's matter has ended. Actually, no complaint is there. No FIR is filed.
But charge sheet it was included.
Yes. Charge sheet is included on a basis. That answer is less than 40 lakhs.
Above 40 lakhs.
No, maybe about 40 lakhs.
40 lakh question.
How will you get over this circular? Your circular 75.
Circular is only an internal communication. Miller, circular cannot override the statutory provisions. Miller, here, the Lordship of my Lord,
those are executive instructions.
Here, no, here, this Honorable Court directed him to investigate under the OPID Act.
When that order?
I want to know that.
Miller, unless that order goes, it stares at us, Miller.
we are placed between the dilemma of two horns. We will always be the lesser Miller. So there is the violation of the
They could have received that order somewhere.
Yes, they should have.
If that order stands, then that circular goes. The effect of circular goes.
So that order doesn't stand with due respect.
Let us see the order.
You kindly have a look at page 27.
27. Yes. Yes.
Sir, the court which passed the order subsequently has made a
many matters stand.
Yes, yes. Actually, group of matters were listed. Court never indicated individual case. If Lordship looks at taking into consideration suspect, it deemed proper to dispose of all the above shares in the club together with the following direction. In the case in which FIR has already been registered by the concerned ISC, the concerned police station, the investigation to be taken up fairly, steps to be taken, apprehend, arrest accused persons if they are not otherwise in bail, there is no longer. In case where FIR has not been registered, steps to be taken for ISC, concerned PS to take within 15 days and so. It was made clear that FIR not registered as per the above direction, case also and so, liable for contempt. That is the reason why universally they registered everything. I read your the other order.
Where does this order says that it has to be investigated by UW? It only says that IIC. Yes, Mr. Justice Miller. What does it say that it will be investigated by the UW?
It was registered by the
concerned police station, it says.
Right, Miller. Police station. Right, Miller. Therefore, Lordship kindly see, we have referred that subsequently the Honorable High Court, your Lordship may kindly turn to page 66, Miller.
66.
Miller.
Yes.
Yes. I just read it.
Yes.
In obedience to the order dated 19/12/2018, the Honorable High Court of Orissa, the present case is registered, treating the original complaint dated 8/8/17, along with enclosures filed by petitioners in depository author as FIR, which is enclosed here. On registration of the present case, UWPS case number, initially it was registered by the General Police. Since it involves an offence under the OPID, UWPS case number 4 dated 1/2/2019 under section so read with section 6 of OPID Act, the investigation of the case is entrusted to Inspector Nivedita Das of UW.
There is no direction to that effect.
No, direction was to register at FIR. Yes. The ISC registered it FIR under section 6 of the OPID Act.
Yes.
The moment it is registered as a offence under the OPID Act, the Lordship kindly see section 6 of OPID. Section 6 does not require any amount, any person. Even a single person can be charged. Kindly turn to section 6, Miller.
Yes.
Yes. My place, Miller. Notwithstanding anything contained in section 3, where any financial establishment defaults the return of the deposit or defaults the payment of interest on the deposit or fails to return in any kind or fails to render service for which the deposit have been made, every person responsible for the management of the affairs of the financial establishment shall be punished with imprisonment for a term which may extend to 10 years and with fine which may extend to 10 lakhs. And such financial establishment is also liable for fine which may extend to 1 crore rupees. Now, the Lordship may pause here for a moment. So, what section 6 says, any person either fails to render service or responsible for service for which the deposit have been made. Here, so admittedly during investigation it has come to light, Miller. Apart from the petitioner, there are other 3 persons those have been due to the tune of rupees 40 lakhs some odd. Now he is before the lawsuits saying that there is no case made out under the OPID Act was not said. It is his prerogative.
Because of that judgment of the covenant bench which is pending in Supreme Court.
Yes. Now, your Lordship has seen.
Group of matter is pending there.
Yes. Now, your Lordship has seen Section 6 in its scope and ambit never envisages, Miller, that what would be the amount cheated? How many persons is required to be cheated? Section 3, your Lordship will say, see Section 3 and Section 6. The legislature has intentionally made the language, included the language in Section 6 in a different manner.
Now, on the face of this, why this executive instruction then?
Well, that can be, your Lordship can say, no executive instruction can override the statute.
But those things are there, why have you issued them? It is you issued it. Contrary to the statute.
Minister cannot make things correct, Miller.
On the plain reading of Section 6, it has got no application to the statute.
That's right. That will be decided by Supreme Court. That's pending there.
Already decided here in Supreme Court.
But there is another judgment which says that it is pending to them.
Yes. So both the cases you can also consider.
And the Supreme Court they say and both the judgments have gone to Supreme Court now.
So let's stay with there, continue, let it
waiting, let the Supreme Court here Section 6 for builders are not that the issue. This is argument. I know. See that contrary view of two bench, which is pending in Supreme Court.
Yes.
Let the Supreme Court decide, stay continue, put it in the January. Stay continue. If you are saying that, but why have you issued that 75 days?
Your Lordship, can you see the circular again? That has been incorrectly placed before you. If it is less than here also
now Section 6.
No, yes, your Lordship, can you see the circular? Clarified. Even if it is less than 1 crore, it can also be used.
20%?
Yes.
20%.
20%, 40 lakhs is more than 20%.
20% to be seated. Minimum 20%.
That is relating to Section 3, not Section 6. Right.
When say that?
Section.
No, don't read section. Tell me the circular. Why are you issuing the circular? Look at it.
Last 4 lakhs.
The circular is meant for some particular person. Some person, not everyone.
Interpretation by my senior, I cannot level any other allegation. Can you see the further last 4 lakhs?
Yes.
Further economic offences involving Panama. Can be investigated by UW with the permission of the other side. If in view of the particular offense, Mutum Saparani or its connection with other cases under
I'm not taking the permission.
in UW, such investigation is a
Then the special procedure prescribed. Have you taken permission?
Is it his case that I have not taken?
No, that I am not in so I think this executive instruction is designed to give benefit to couple of people. And not to be used for others. That looks like.
Let the Supreme Court decide.
Let the Supreme Court decide. Let the Supreme Court decide. Because that issue has to be settled. Whether Section 6 insofar as the builders will be applicable or not, because there are two views of this court. And both the views are under challenge in Supreme Court and which is pending. So unless this is decided, we can't take it.
Miller, not 2 views, Miller. There are 4 views.
I am
is considering 3 views in my paper. So therefore, the 4th judgment says the comparing view is a foreign inquiry. That I have given your Lordship.
Now, in that particular case, it is pertinent because it was not noticed. The earlier judgment was not noticed. By the court which
Miller, I cannot say
he was not interpreted Section 6. Where the subsequent judgment has been interpreted. Section 6 is interpreted.
Miller, both the other 3.
Personally speaking, I am with the view taken by Justice Panigrahi.
Miller, I will just say the converse.
Because one step ahead, and in the builder's case, you can maintain a complaint case before the consumer forum also.
Yes.
So that judgment is not taken care of.
Clarifying that question for your lordship family. Your lordship, every action has got two alternative action. Suppose it is criminality in nature also. The remedy also in civil in nature.
Yes.
So these
Both things can go to.
both can run concurrently. But if the civil case is decided fast, it has got a binding effect on criminal case.
Right.
But the criminal adjudication has got no binding effect, so far the civil matter is concerned.
Now, standard of proofs are different. That is beyond reasonable doubt. There preponderance of probability.
If there is a
different.
there is a preponderance of probability and confident.
Then that is binding on law. Obviously. That is beyond reasonable doubt.
Yes, but however, the entire decision of in India says that civil courts adjudication, because it is an adjudication after hearing both the parties.
Yes.
In criminal case, both the parties has never been heard. In criminal case, the person who has been cheated, he has nothing to say. He is a mere witness. Everything is left to the investigation. It's an agency. A special statute has been created for that purpose. Therefore, my submission in the previous case, which was decided by Hon'Ble Justice Hon'Ble, though the three previous matters were placed, it was not taken into consideration, for which it is still lying before the Hon'Ble Apex Court.
Yes.
Lordship is correct. If the Honorable courts decide in one way, it has got a
Again, standing with you there in Supreme Court. So it's better now. Let me decide. Awaiting the judgment of the Supreme Court in which Rashmi 40, no?
Right.
SLP number is there? And that is the matter. Is the matter.
Because I am assisting your lordship, I cannot counsel. We are all assisting. My Lord Senior is misguided. Suppressing a person.
Sir, we are reading a law. Awaiting outcome of this list and interim order to continue. Yes. Yes.
73.
Interim order to continue. Yes.
It's a case of a lady who was holding the post of the principal. Then there was some grudge of the next below, who was also another lady.
Yes.
And both of them were very, very anxious for the post of that.
Overheat planning number 2, sir?
Sir.
Huh? Sir,
yes. What has happened below? In 2012, the affair has been lost. That is at Annexure 1.
Yes.
Till date, my lord, the investigation is not complete. 12 years have passed. And in the meantime, what is the development?
1/5/2012 FIR.
Yes, my lord. Till date, no charge sheet.
You had taken
more than 12 years.
Have you taken any stay or anything?
No, nothing. As your lordship will find also, under Annexure 5, the SDPO has given a report that the case, there is no material. That is also Annexure 5.
Annexure 5, huh?
Yes, my lord. That is at page 35, my lord. Page 35 it runs. Your lordship will find at page 37. 37, the concluding penultimate para.
Yes.
It is needless to mention here that prior to this case, Srimati Banani Patnaik had lodged complaint against Srimati Kavita Mahapatra. Kavita is the petitioner of my lord. White Banki PS case number such and such. In the said case, audit was made by the Department of Higher Education, Government of Orissa, and compliance report was submitted by Srimati Kavita Mahapatra, ex principal in charge, so and so, to all concerned authorities in due time. But intentionally, Srimati B. Patnaik not forwarding the same to the government for necessary action at that level, for which 2 reminders and 1 explanation was also issued by the Finance Department
of Higher Education, Government of Odisha, to Srimati Banani Patnaik.
Now, this report is pertaining to this present case.
Yes, Lord.
And
what is it between this
what do you say? The last paragraph says that this is manipulated only to harass this lady, Kavita Mahapatra. Yes. This is the report of the
SDPO, my Lord. SDPO in 2015.
Yes,
I am sorry, my Lord, the public secretary is running this case, madam.
what do you say you are appealing for? Are you serious about this case?
It is not written some of one.
Now leave it here.
Dear Lords.
See, the report of SGPO says that from the above fact, evidence and record, it is evident that to disturb Kavita Mahapatra, that is the petitioner, from the post of principal in charge, Srimati Banani Patnaik, that is you. The petitioner has fabricated the above criminal case, and in spite of so and so, the principal in charge has been forcefully so and so. Yes.
I have no instruction about annexure having.
I think you have harassed
authority.
Stop it. Will you seek instructions?
No.
What are the offences?
403, 409.
Yes, what do you say, sir? 2012 FIR. No charge sheet filed. On this ground, alone I can cross it.
Only one chance, one more chance required.
By way of last and final opportunity, the State Council seeks instruction to file an affidavit. You file an affidavit. Stating the cause of delay in filing the charge sheet and charge sheet in the present case. Who is the IIC? Banki police station. I'll straight away give a direction to the IIC Banki police station to file an affidavit. IIC कर दियो. IIC Banki police station police Cuttack is directed to file an affidavit explaining the delay in conclusion of the investigation in the FIR number FIR 114 bracket 2 about 2012. 2012. Last and final opportunity granted to the parties, the opposite party number 2 to file a response if any. Lease the matter. So it's made clear that no further adjournment no further adjournment shall be granted in this matter and free copy granted. Yes. Immediately after vacation of the OTC, Otis 28. 28. 29. Okay, 29. Yes.
29.
29. Time has no sense, I'll take it. Yes. 29. Yes.
My lords, I appear for the petition in item 74, my lords. Lordship, this is a petition filed by the petitioner, my lords. Am I audible, Lordship?
Yes.
My lord, this petition was filed, Lordship. The petitioner is a director in Artha Tattva company, my lords. And Lordship, this relates to, Lordship would recall, this relates to that order that was passed by the Honorable Supreme Court of India, where Supreme Court had directed, my lords, that because what was happening, my lords, is FIR was getting registered in different places, in different police stations, for the same cause of action against the directors of Artha Tattva in different places in Odisha as well as in West Bengal. So, my lords, the Honorable Supreme Court, with its order dated 9th May 2014, had transferred the investigation from the local police authorities to the CBI and said that CBI will take over the investigation. Pursuant to that, my lords, CBI had filed a charge sheet, filed a supplementary charge sheet. I was named, I pleaded guilty, my lords, and I have already undergone incarceration for 4 years, rigorous imprisonment for 4 years, as was directed in my sentencing order. My lords, despite that, after having undergone that, in the exact same circumstances, my lords, the respondent number 1, there is an FIR registered of 10th May 2013. The first time summons are issued, my lords, which is what I've impugned before this honorable court, was in 2021. 4 summons have been issued, while despite the fact that for the exact same circumstance, I've already undergone custody. I've already undergone my entire imprisonment period, my lords. So, Lordship, in this FIR, Lordship, the FIRs which the Honorable Supreme Court had said should be transferred to CBI were all filed around about February to about May of 2013. This particular FIR, my lords, where the summons have been issued, process has been issued against me, this impugned FIR is also dated May 10, 2013, my lords. But despite that, for whatever reason, my lords, it was probably left out or whatever, my respectful submission is, my lords, that this would amount to, of course, violation of my rights under Article 20, Subclause 2, as well as Section 300 of the CRPC, my lords. Well, there's no reply filed by respondent number 1, which is...
Let us verify how these three cases, two cases or 3 cases?
One case only, my lords. There's one FIR.
One case, how it escaped the notice for the investigating agency. Let us see. Issue notice. Let us see.
I apologize, my lords, I wasn't...
Yes.
That is the second sub item. I don't know why it has been tagged.
Well, I also don't understand why it's been tagged with that matter, Millers. I don't understand that 711 Lordship is probably...
There is no order for tagging?
I don't know.
No, my lord. Last occasion, Lordship directed similar issue was that case was conducted by my senior. You received directed that you inform that you take instruction from me because he has conducted similar type of case.
Well, also, what has happened? The CBI has inquired into the matter.
No, what she says is the Supreme Court is directed to club all the matters and investigate. And what has been done is all the matters were clubbed. He pleaded guilty under the sentence is completed, 4 years completed. After that, one case they have registered and someone is issued.
Yes, sir.
So he pleaded guilty thinking that my entire sentence part is taken care of.
I'm not concerned with the other case.
Yes.
My case is again, it has no connection with this case.
Your Lordships, I am appearing for CBI.
Yes,
there is some problem in my video, Your Lordships.
It's all right. Mr. Raj?
D-tag, Millers, there is no similarity, Millers. It may be D-tag, my case will be heard independently.
Yes, I have detailed both the matter.
Your Lordship, fix a date.
Millers, in my case, Lordship, may I request Lordship to fix a date for final disposal only, Millers, because
let Mr. Naik file a reply to that. Okay. Second matter detail.
My entry orders will continue.
Millers, CBI has already filed a reply, Millers. The state has not yet filed a reply.
Yes, fine. Yes.
36.
State has nothing to do. It was fixed. What is this matter?
138 and 2000 terms, 2013 is the revision.
Who is appealing those?
The last 2 days they have not been appealed. Those have been adjourned, they have not been appealed. 92%. 138 and 2010 matter. 2013 is this matter. And that time the amending act had not come, that there was no deposit also now.
What the complaint?
And the complaint.
What do you want here?
The other side is not cooperating neither.
What direction you want? Expedite.
It's a confirming judgment. It's a division against a confirming judgment. He has been convicted by both courts.
What are you challenging them?
They are challenging the confirming judgment.
They are not coming.
They are not coming.
But this is it. 138 matter. Convicted by both the court. But then petitioner. It seems petitioner is not interested to prosecute the case, hence the petition is dismissed. Yes, 92 dismissal. Let us. How many matters have there?
200 left. 18 matters.
Let us go. I am sick. Little more than.
And to disposal.
See, 138 meter, 2 courts have committed, he doesn't come then, what to do? Matter yes.
Since I filed matter, no, I have not. 139 matter. State also the party matter.
But in fact, matter since it's a commission against the commission matter, you also have to decide
dismiss in default because it cannot be state offense. But there are the not the state offense. So if it is a state offense, then I have to appoint a magistrate.
But what happened, matter? My submission matter.
There are some certain decisions there matter.
In commission matters matter, you can dismiss for non-prosecution matter. It has to pass. This is
commission matter.
It is not an appeal. It is
Also,
so many any case of commissioner court can't be 138 bad. It is a quasi criminal, basically. Quasi criminal. 138.
Since against the commission matter, it also has to decide the case on merit, otherwise can dispose of non-prosecution matter. That is the default matter. There are certain decisions of non-appeals court also.
Put it tomorrow. Put it tomorrow. Then I will pass a detail. Non-appeals for the petitioner. By way of last and final opportunity, release the matter tomorrow. 3:30 and Mr. Raghuda, if you have some judgment, if that is the case, then I will pass a detailed order. Yes.
Can dispose on merit matter.
Merit if I have to, because it is a revisional jurisdiction. It is not an appeal. Therefore, I can dismiss it. That is my view.
My friend,
Yes, yes.
For that is I'll assign to me my party for that.
Yes.
76.
76.
This is the case where yes, bank is the complainant here, my lords. And on the last occasion, placed two decisions, my lords, Nikhil Merchant and Vivi Agarwal. And my lords had put a pointed question to me that in either of these two cases, in the OTS, was there a similar condition that the criminal case will continue? If my lords recall, there is one condition in the OTS which says that the criminal action shall continue. My lords said that it the two cases.
And you regard upon two judgments where I said that in those cases whether
it is a similar condition.
Yes, show me that.
My lords, indeed, in BB
For the information.
Yes.
The 9 is
Mr. Naik is for severe.
Mr. Naik is for severe.
My lords, I'll just pass on the compilation which I had given last time.
But where is Mr. Naik?
There are some connectivity issues Mr. Naik is facing. Your Lordship may just give one pass over. I'll just confirm whether
Yes. Yes. Yes.
77.
Have you served the compilation to both of them? You got the compilation. You answer to that, limited to that point. Okay.
77 you have seen class patent directed in criminal case 3576 2022 was tagged.
Yes.
So I have sought instruction like there in that numbers. So I that madam listed application, but I will
You're asking a fixed date and you're asking a hard matter. Hard matter. I'm giving a point maybe to Rossi with the permission. In case where the loan account has been closed by the bank, therefore Rossi was taken note of. In two cases, the borrower has already closed the account, no objection has been issued by the bank. So this case is something different than that of other cases, those where
couple of cases.
Yes,
out of 52 people, 11 people have paid depending.
No, I'm not.
By forging the seal and signature.
No, that is
because of you are paid is
You are the bank. You got the money, don't go.
Yes, my lord. In Mr. Rossi's view, recent decision of the appeals court has come on. I'm surprised. Rossi's couple of months before viewed this, and yesterday appeals court has viewed the same line. After vacation, it will be better.
Thank you.
Interim order was
Interim order to continue.
But 56.
First week of November. First week of November.
One more
item 56 milord, let's say after vacation, any short in date.
56 what is it? What is it?
ମୁଁ ଆର୍ଗ୍ୟୁ କରିଥିଲି ଯାର ଦୋକାନଟା ଲକ୍ କରିଦେଇଛନ୍ତି ସେଇ ଜିନିଷଟା ହିଁ
Non-appeal to what?
ଦୋକାନଟାକୁ ବନ୍ଦ କରିଦେଇଛନ୍ତି
Yes. Yes. 70?
79.
May I please, my lords? My lords, am I permitted to appear through virtual mode, my lords?
Yes.
There's an application for washing of proceeding against the present petitioner, my lords, who happens to be named, my lords, in the FIR, but in the charge sheet, my lords, completely has not been disclosed.
I'm hearing a matter, right? 78 ballots. This is, I think, some other matter I'm hearing.
Oh, because your lordship had not dead.
I don't know, I'm hearing some, I am between some hearing. How can you, this is very unfortunate.
No.
Don't convert this court to kacheri.
An adjournment was taken.
Maybe, but you should be there in time. It's 4 o'clock, you don't come and you hearing your attack and you interact. What is this? Let us have little decorum. Yes.
My lords, initially
Yes.
FIR was registered for the offense, for an offense under section 420, 120B and 34 of the Indian Penal Code, my lords. My
Yes.
lords, preliminary charge sheet was filed, my lords, wherein I was not cited as an accused and I was not apprehended by then. 2 other accused persons apprehended, one Somyakanta Mahanti and Raghunath Behera, my lords.
Yes.
As per their statement and disclosure before the investigating agency, it is stated an amount of rupees 69 lakhs was deposited by the complainant to them on various occasions. Thereafter, they stated that they had made deposit of 10,000 to the account of the present petitioner. Petitioner is a lady and is a doctor, my lords. I have appended those documents at Annexure 3, my lords. My learned senior in VC appears for the complainant, my lords. My humble suggestion, my lords, I am ready and willing to pay the said amount 2 lakh 10, which I am not at all in connivance with them. I have not done that. But for settlement of the case, my lords, I pray lordship if my...
How many accused persons are there? How many accused?
My lords, 2 accused in the preliminary charge sheet, my lords, Somyakanta Mahanti and Raghunath Behera were charge sheeted. I was not charge sheeted. I am on bail, my lords. And the investigation discloses they had duped the present complainant, my lords, to the tune of rupees 69 lakhs in lieu of giving admission to the daughter of the complainant, my lords. I was working in high-tech medical, and the story runs as, my lords, the informant came and the present petitioner both.
I am appearing for informant, my lord. My lords, in this case, rather she was the facilitator and having connection with all the accused persons, rather complicit, my lords. And in the case of the FIR, she is named, and in the final form she is named. In spite of that, it is averred.
How much you have taken from you?
My lords, it is not they are a group of people, my lords, who have defrauded various people in the entire state of Odisha and outside of Odisha. This is one of the case, my lord, which is before your lordship. So that does not mean that
she has got no criminal proclivity. With all due respect to my learned senior, my lords, she has got no criminal proclivity. And lordships में 3 annexure 3, my lords. I am a MD medicine, I have a MD in pediatric department, my lords. I am a doctor, my lords. The complainant happens to be a doctor also.
You should have concentrated on your practice instead of doing all these things. You are having.
I am just a victim of circumstances.
Let her face the trial, my lords, because she is named there. Now,
if lordships
in final form,
parents are paying what to do.
Sorry,
no, my lords, I am not on that ground, my lords. The entire investigation reveals all the amount, the entire amount was transferred to Somyakanta Mahanti and Raghunath Behera, my lords. Through
That's
account,
right. Those are part of
the trial.
What I humbly pray, if lordships may direct it for mediation, my lords, I am ready and willing to pay the 2,10,000 that has thus come up.
1 minute. Mediation with whom? How many people?
with one, my lords, in this present case, only one person has been duped. What my learned senior submitted, my lords, there is no such
My
allegation
lord,
that there
the
are thousands of.
day before yesterday, the one.
You raised all these points before the trial court. You argue all.
Lords, my statement has also been adduced by the investigating agency, my
Well,
lords.
I'm not going to quash the case like this. You argue all these points before the trial court. I'm not inclined to regard the head to the nature of allegation and gravamen of offences. I'm not inclined to allow the present petition, however, liberty is granted to the petitioner to raise all the points at the appropriate stage of during the trial. Yes. Before the court will, yes, certainly.
78, just this.
What happened?
On the morning, I think my learned senior took an
What
action.
do you mean?
In the morning, who got judgment?
Yes, somebody mentioned.
Ashok senior advocate. Mr. Ashok senior advocate.
For opposite party number 2. So our name may be recorded.
Yes, record the name.
Record. That is all.
He requested for personal law.
Object to that, but
You are presence will be recorded.
only presence may be recorded.
Okay. Thank you. Yes.
82.
My lord, item 80.
Yes, my lord. 80.
Ruling argument.
Morning somebody mentioned and got it adjourned.
I'm so sorry, my lord. Nobody informed us. Absolutely right. No worries on that.
We knew your brother. Yes.
So great.
Yes, my petition is challenging order dated 6/12/2022, my lord.
6/12?
2022.
Yes.
Well, he is challenging that 307. So for 307 specifically, my lord, is concerned, there is no any intention, no criminal intimidation, and nothing has been there in the mind of the husband. The petition is the husband, my lord.
What is this judgment?
My lord, the allegation is that, my lord, there is no specific allegation, my lord. So far, 498 is concerned. 498, it has been executed by the learned CJN court. The order which being again challenged in the.
Oh, charge against 307.
Same charge on 607 is like similar.
Yes. And revision filed, revision dismissed. Show me the allegation.
It is partly allowed by the CGM, my lord, non-CGM.
Yes.
But so far the district judge is concerned, additional district judge, he is dismissed in the light that 307, so far 307.
Where are those judgment except FIR and this thing, the original court judgment, you have not filed anything?
And for that.
What kind of petition people are filing? I don't understand.
Yeah, I am relying upon.
Where is the charge order? You show me the charge order. Where will I get the charge order?
I am relying upon the judgment that is 2000.
You will rely later on, but show me the charge order. You are against by the order of charge. That order is not there. Except that everything is there.
Then I have to make it. I have to petition. That it is on.
Why will be challenging that charge order, original order you have filed? I don't. The simply adjourn counsel for the petitioner seeks to file additional document to substantiate his case. News to matter in December. Yes.
83.
December last week.
After vacation,
December is after vacation only.
Yes.
I can't wait for you. You don't file the proper petition. Don't waste time like this.
83.
We see many people. There are few counsel came from outside waiting.
83 and 6.
No.
83.
Then I will impose cost. 1,000 rupees. Because in the last occasion, I will take it immediately. Don't argue. 10,000 rupees cost. Go to the bar association. No. 10,000 rupees cost. Pay to the bar association, and I will take it up immediately after vacation. I try with yours. 83. Both husband and wife. Maybe you do this kind of work when you want to suffer. Yes. Next.
83.
I only sorted my lordship after vacation.
Yes, 83. Same.
83. I am paying for 83, my lord.
No, next item. Next item 83 also.
Yes.
अच्छा ये अच्छा that matter is over. Okay, now and what you want husband and wife to be appear, and because they are not obtaining the birth certificate of the child, that is why they did not. You must tell that the earlier matter I was talking about. This matter only. How can that okay? I were they settling the dispute. Yes, isn't it? Yes, ma'am. Okay. Subject to verification. They are not obtaining. All right, all right. Any classification because there are old people. Okay.
84.
Let's see, in item 84, paying for adjournment, can it take, this matter may be taken up after vacation, yeah, let's see.
There is interim order anyway.
Yes, yes,
Yes,
interim order.
interim order to continue. Yes.
85.
Obliged, let's.
Yes.
I am challenging the rejection order of the 202 petition 138 NI Act. Amount is 50,000. But the accused has
205.
Yes, madam.
Yes. You are the accused.
Yes.
Yes, sir.
And complainant opposite you. Opposite party number 2.
Yes.
Your lordship.
138 is 205 application. It's legislative approved virtual mode.
Your lordship, 30th April 2024.
Yes.
Your lordship directed to instruction deposit 25,000. Your lordship directed to instruct your client to pay 25,000. 30th April 2024. You kindly one minute. Then 15/5/2024. It is adjourned to 15 May 24. Before week of vacation, summer vacation. It was adjourned to after vacation, but it was listed for September 2024. 3 months after. After vacation, I mean.
What do you want? What do you want?
I want to, what instruction you have taken to pay 25,000, 50% towards check.
Check amount is
50,000. But the he is a fitter, garage worker. He has no account in the Axis Bank. But and the check was drawn he in his name. So he wants to fight in the lower court
by spending lakh of rupees.
That he falsely he is implicated
for 50,000 rupees he will spend couple of lakhs.
That he's hard choice.
I think this
hard choice.
Lawyer and small firm and business.
25,000 rupees you pay 50%.
There is no order. Khali ka instruction करले दे whether he wants to compromise.
That's what I was indicating.
After vacation, I will take instruction. If
the petitioner is seeking was for the petitioner submits that the check amount is 50,000 rupees. 50,000 rupees. 50,000 rupees. Because since he has been prosecuted for dishonour of the state check, he counsel for the respondent opposite party submits that even if the petitioner pays 50% of the check amount, he will not press for the he will not prosecute the petitioner. In this regard, the petitioner seeks to appeal instruction from the petitioner leaves the matter. Okay. Immediately first to the supervisor. Come with the 25,000 rupees and finish it up.
Okay.
Yes.
86.
86 lordship cannot be from other day lordship because I am on a BC lordship.
Let's see. Last
Other day lordship.
also seeking time, let's see. Let's see. Today he has examined wrong. Let's see. Sign agent. Improve to continue. Yes. This specific date. Let's see. Yes.
The last occasion, Lord asked me about that registration and the financing of the trucks, my lord. So the DA case for the discharge petition has been rejected.
Yes.
Lord, I found out from the invoice. May I pass on an invoice, Lord?
Give it to.
Yes, well, the first page is that serial number 21 of the assets of the charge sheet, my lords. Let's look at the invoice, lords, on the left hand corner, my lords. It is written under invoice, my lords, sold to HDFC Bank. And the owner is HDFC Bank, my lords, and delivered to your hirer, Anil Tomar. I had last said, lords, that it is a hire purchase agreement.
Where is that?
Well, it's under invoice, my lords. Left hand side, lordships, will find sold to
HDFC.
and below is delivered to your hirer, Anil Tomar. That is the petition hearing, lordships. Here. And my lords, on the price charged, diagonally, my lords, on the right hand side, 10 lakhs 40,950. Yes. And on the left hand side, my lords, I have rechecked engine number and chassis number are the same. And below that also, my lords, the RC is also enclosed.
Yes.
But there are two vehicles of HDFC which my learned friend was confusing with the IndusInd Bank. I got clarified that what has got it refinanced after repaying this loan. So there is a refinance of the same vehicle, same registration. Once you get your loan clear from HDFC, then you can refinance with subsequent bank. The value becomes lesser. That is the definition of the vehicle matters. Long and short matters, all the four vehicles in the assets are 100% financed and hire purchase. Matters, last we had seen that there are two vehicles which are hire purchase Tata Finance, and logic knows that in hire purchase, the vehicle is owned and purchased by the finance company. There are four vehicles in total. Tata Finance also had shown, I will again show the pages, lordships. And these two lordships got a bit confused. I will not be unable to explain as to why the IndusInd Bank comes to finance same vehicles. But as this invoice, the same chassis number and engine number are purchased by HDFC in the first go in 2005. Then subsequently, they got a refinanced. I'm not in the second part. I'm the first part. Now, when the asset is owned by HDFC Bank, well, how can I be robbed in? And 100% finance managed. While I was seeing the invoice, seeing the purchaser, and seeing the amount. Now, it's the asset column of that charge sheet, my lords. The my lords, 1 second, I'll take my lords to it. Particular thing, lordships. Yes. Now, then come to page 73 and 88 of that page, my lords. Same four vehicles.
73.
88 lordships.
88.
Yes, lords.
Yes.
Now, even the investigation, my lords, they say the 9 lakhs is the value. Well, I am saying that it's 10 lakhs 40,000.
Yes.
And interestingly, in the single list, these RC books never feature. And on what basis, my lords, the special judge applied his mind? On what, in FIR, my lords, the vehicles are not numbered. My lords, search and seizure, my documents are not finished. My premises not searched. The delinquent officer and 6 other persons' house were searched. Not a single document regarding these four vehicles, my lords. Even in charge sheet, which is full up to 17 months, lordships.
Yes.
No mention of these vehicles.
173 total.
No, no,
yes.
And on what basis should I face trial, lordships? And it will 12 years, my lords.
Yes. Have you seen it?
Last occasion, your lordship, perhaps I have.
And my lords, one more thing, may I just submit one finally? My lords, this petition is going unreported, I am telling you. This petition, they are not filing a reply, is going unreported on only verbal submission.
No, that's right. But in criminal proceedings, on not on the basis of pleading we decide. On the basis of document we decide. And if it's not a suit that a decree will be passed.
Recently, my lords, the judgment has been passed by under Supreme Court in 22. They say that some reply or some
in a criminal, but see, hold on. Now you deal with this also. Reply, you deal with this also.
All respect, my lord. Can all those the documents they are filing there?
Whether it is not a charge sheet.
No.
Whether
not a civil document is part of the charge sheet.
So you deal with it and find the reply.
I have given the reply. I have given also filed what basis and reply along with the lordship can be seen. And I have put a number of judgments. I will
number of judgment, and so the time and again that on the section 122 is there, and document, he has no right to file any document, and that he has no jurisdiction to enter any at all. Yes. But in that case, Lord, will rely on justice, that service judgment by lawyers, they say that the charge sheet needs to have material to prove. On what basis they are having the charge sheet matters. Wrong or right, they file a charge sheet. Whether you rely upon the documents. But on what basis? Whether these documents are form part of the charge sheet or not has to be seen. But it's not present. Whether these documents which are not part of the charge sheet can be relied upon. Minus that. Lots of make it preliminary submission, most fundamental submission. Out of all 4 vehicles, none of these RC books are in the seizure list. Not a single RC book, other books are mentioned in the seizure list. On which document are they relying? Once the vehicle is attached to the asset, RC is not present. It is not in the charge. You show me any judgment which says that the obvious document. We said immediately not considered. We said whether that could be considered. We said obvious document. Yes, madam. If you say that the vehicles are Benami vehicles, the obvious document is the RC book. Correct, madam. And the obvious document is the invoices. If minus those documents, if you file the charge sheet, whether those documents can be relied upon for the purpose by application or not. Application submission, even the 2% of the if it is not filed in the charge sheet, no question of considering those documents, that will be tested in the trial only. The second part worships. Yes. First principle, first part the charge sheet should be based on some documents. Otherwise, you can't pull out a charge on submissions of the IO. Yes. These are the physical case worships. Show me some. I will be. Put it, I have a compilation of judgment worships. Sorry, judgment in 2024 Supreme Court said that the charge is a copy of this to him. I only supply worships. And let me partner application. So what I humbly play my lord, whatever document he wants to file, let him file. I don't file this document. This is the statement that he will file no more. No. The document is relying, it is self-contradictory to each other. That's why let me correct. You copy it, okay? And keep it. Mr. Maharana has placed on record the objection. Objection. Advance copy has been supplied. Keep it on record. And Mr. Samantray has filed an additional document and submits that he would not file further documents. Yes, sir. Further documents. Objection about copy. I also saw the copy of the instant document. Yes. Objection has also, sir. Yes. Well, it's any date at date include part and not. Yes, part. Yes. Yes. The last petition, the state was directed to file the affidavit. 88. Yes. Lordship, my kindly have a glance at the affidavit, page 5, Lordship. Which affidavit you are talking about? The state was directed. Lordship, by order dated 14/8/2024. 14/8? 2024. Yes. Lordship, my kindly have a glance at para 7 of the affidavit of the IO. So file the affidavit. Yes. They have already filed. Lordship, may kindly have a glance at Vijay Kumar Majhi. Yes, sir. Yes. Page 5, para 7. Yes. That it is respectfully and humbly submitted that the present deponent inadvertently submitted a charge sheet after statutory period. That is on 181st day. The present deponent gets unconditional apology for such mistake. Lordship, they have admitted that they have filed a charge sheet on the 181st day. Lordship, this matter arises out of a default bail matter, Lordship. And they have admitted that charge sheet was. Have you filed the application under 167(2) immediately? Lordship, it was filed after. Lordship, will not get benefit. Lordship, I will satisfy your Lordship in that aspect, Lordship. Lordship, the matter which my learned friend was referring. Before the charge sheet is laid down. Yes, sir. Your application under 167(2) has to be there on record. Lordship, I was not produced on that very day. Lordship, I was. Then you lost the train. Lordship, it is the duty of the court to intimate the accused, and there are various number of judgments in that aspect, Lordship. Lordship, in Lamberton back, it has been categorically stated it is the duty of the court to intimate the accused of his default bail, because his indefensible right will be violated, Lordship. And not the accused was produced,
Not
When your application was there and that day the charge sheet was already there.
Lordship, I will satisfy, Lordship, my agenda this matter, I will satisfy on.
After 2 days, my lord, he has filed the application.
That's the problem. Otherwise you had a right.
Yes, your lordship, yesterday your lordship that on trial.
In that case, which my learned friend was referring, Lordship, in that case, the charge sheet was filed on the stipulated period, but it was incomplete charge sheet. On that basis only it was referred.
But that's the law, because you are right, excuse the moment charge sheet is filed.
Yes.
But it's the.
You are right, stay, the cause of action stays the 180th day until your charge sheet is filed. In between you encash
The charge sheet was submitted after 2 days, he has filed bail application. So automatically it's right status, madam.
You satisfy me.
Lordship, in case of.
And come with some judgment so that we will try to find out.
I will also give some judgment because that judgment also categorically stated once the charge sheet has been filed.
Then your cause of action goes.
Right? Serious.
Lordship, I will satisfy in that.
Okay, in this matter. Yes.
89 or 88?
Huh? No, fix out 18, yes. 89?
My lord, may I plead the lordship? My lord, I am appearing on behalf of opposite party number 2 in this case. I pray for some time, my lord.
Yes.
To
The mediation, the order of the mediation record that you will be filing joint petition, joint compromise petition.
Fine.
But I have instructed, there might be some deviation. And then the book is approaching the lower court, the date is on 26.
Have you arrived at a settlement or not?
That is that because the mediation was on 6th of it was on like last week only. So, but there are chances of settlement. But the
Mediation process is still going on. These matters are sunset. Yes.
I'm seeking for that. The interim order, because lower court I have
Meantime, then counsel for the petitioner may move an application for the trial court seeking an adjournment. Seeking an adjournment, if such application is moved, same shall be considered in the light of the fact that mediation process is still going on. Yes. Next.
90. 90. That's my friend.
I request item 9 to have one clarification. There are two cases actually, my lord.
Yes.
Pursuant to this order, only in the internet, only one. So the order that was passed has been printed and it has been printed in only one case. And the second case, that part is empty, my lord. I am unable to take out the order copy.
इसमें करो रोज दोनों में प्रोसीडिंग बना के लगाओ प्रोसीडिंग both the cases
Both the cases.
Yes, let me get this process. A mistake in our office. Yes.
91.
दूसरा मैटर किसी दिया प्रोसीडिंग लगेगा ना वोटर लेवल कम किया ठीक है.
In this matter, the petitioner 6 question of convenience order dated 29/8/2023, advocate both the parties have amicably settled the dispute, and I have understood.
Bring them. When?
If possible, direct then
Tomorrow?
any.
tomorrow.
Day after tomorrow. Day after tomorrow only half an hour we have court. Half an hour. After that, tomorrow. Okay. Tomorrow you bring them at 2 o'clock.
Yes.
2 o'clock. Tomorrow 2 o'clock. Yes. So don't examine it. Spill over to tomorrow. You will come tomorrow sleep. Spill over. Yes. All the matter tomorrow. Pass over how many bit?
176.
Okay, 76 pass over. Huh? Yes.
So the pass on the confirmation which I had given last time.
Yes.
Yeah. There's an index after the written submission, there's an index. This much. Serial number 14. But page number 14. The High Court judgment of PV other one, which I tried up. In the High Court judgment, the terms of the OPS have been recorded.
Well, yes.
I'm just pointing out. Page 14, the judgment starts. The High Court judgment. At page 22.
22.
Page 22.
Yes.
Para 8. This para 8 is quoted from the affidavit of the bank which has been filed with the OPI. I see that during the year 2005, after initiation of surface action, Mr. Sunil Patel, naming to be director of applicant number 7, had given the one-time settlement proposal. I see that after negotiations with the said Mr. Sunil Patel, the respondent of fund, accepted the offer for 1.20 lakhs on various terms and conditions set by the respondent of fund. The acceptance along with the terms and conditions were informed to concerned parties wherein it was clearly mentioned that
Shall not interfere. Further it is also clear.
so the bank had there also said that they are
Shall not interfere. Yes. Yes.
Which is also. And even in paragraph minus.
And this was confirmed in the Supreme Court.
Confirmed.
Yes.
Even in
Page
paragraph
22. Page 22. Page. Yes.
And was last occasion I showed Nikhil Merchant and B.P. Agarwal.
22.
I was in this very compilation. At page
Next,
25.
which page?
Page 25 minus.
25.
This is CBI versus Sadhuram Singla.
Yes.
Again, my also can we see at page 26.
Yes.
Rather, page 27. On the basis of forged documents and forged bank guarantee, 28.49 crores.
Where? 20?
Page 28, 27, my lords.
Which para?
Top of the page, just above para provided.
27. Serial number 27? Page. Running page.
Running page 27, my lord, in comparison.
Sadhuram, huh?
Yes, sir.
27. Yes.
Just about para 4. In para 3, my lords may note that the extent of the loan was doing so. This was taken on the basis of post bank guarantee and this was misuse of funds. Para 4. During the pendency of the proceedings before the court of the learned special judicial magistrate.
The compromise was arrived and the bank of the instructions from prevent thereafter the bank release responsible. Withdraw the recovery proceeding DRT so and so by trader so and so. That nothing due an application filed by compounding the offense. This is compounding offense. This is for compounding.
Yes, sir. It traveled right up to the Supreme Court of this basis that once the OTS has happened, should the criminal case even proceed? Isn't it a
Now, if in the OTS, if it is ascribed that no criminal anything else in that light?
I just wanted to point out other instances where so CBI versus Sadhuram Singla is one such case. Correctness of Nikhil Merchant was, if my lords can have, page 60. Correctness of Nikhil Merchant was doubted and was referred to a reason bench.
Yes.
At page 60, Gyan Singh versus State of Punjab.
They say there is little chance of conviction by the yes.
So, para 61 and 62 of Gyan Singh Malos, they say that Nikhil Merchant is correct. Page 100 of the compilation.
100.
Yes, madam.
Yes.
Para 62 says, in view of the above, it cannot be said that D.S. Joshi, Nikhil Merchant, and Manoj Sharma were not correctly decided. This was the question referred to the three judges. My lords, I am relying on G. Sagar Suri at page 108, starts at 101. At 108, para 8.
Use the mics are
yes.
But I think Mr. Naik is not able to do. Am I audible? Okay.
108.
Page 108, my lords, para 8.
Right, yes.
Jurisdiction under 482 of the court has to be exercised with great care and exercise of its jurisdiction. The High Court is not to examine the matter superficially. It is to be seen if a matter which is essentially of a civil nature has been given a court of criminal offense. Criminal proceedings are not a shortcut or other remedies available in law. Before issuing process, a criminal court has to exercise a great deal of caution. Also, what I'm trying to say is that this has undertones of civil dispute matters. Yes. Now, I will show that there was an application filed before DIT which was withdrawn by this bank. In the paper which management kindly heard about,
I know that. I know that.
Recording that after due satisfaction, full and final satisfaction, the IT application is being withdrawn. This is after I paid the money.
The OTS is acted upon.
OTS has been only thing what I'm now is the OTS that the criminal case will go. One Chhattisgarh High Court judgment, I just wanted to point out there again, the condition was
that Sumita judgment. The condition, I'll just hand it over. I'll just read one paragraph for Sarthak. It is not part of the original compilation knowledge. I'll just hand it over. This compilation, please. Manoj will take the second judgment here.
You have given it to Mr. Naik.
No, it's not.
Yes.
The High Court thing also has not been given, your lordships, which was referring to.
No, that's in the compilation, Sarthak. That's the third judgment is the High Court judgment. In
Yes, in from this compilation.
Management only sees Suman Devi, the second judgment.
Suman Devi, yes.
Now here, I will just show the ATS condition in the page 8, small 8, internal page 8 of the judgment.
Suman judgments.
Suman Devi, this is Chhattisgarh High Court mallet. Internal page 8 of this judgment.
Suman Devi. There is no pagination, nothing.
There's no pagination. There is the first judgment is Duncan Agro. Just after Duncan is there is internal page 8 of Chhattisgarh High Court judgment. Management only see capital A, B, C, D. These are the terms and conditions of the
I see. These shall not withdraw.
Yes. So if there is a similar condition, then management only see what the how the Honorable High Court 15. Internal page 15.
And question.
Second line from top.
Yes.
This is very interesting, Manoj. In the settlement of page 15, second line from top, in the settlement order of DIP dated 30th January 2018, this was recorded that the bank will not withdraw any proceedings filed against the company or its representatives, but the settlement of the account under the ATS will be informed to the CBI and RBI. The said action of the bank will demonstrate the intention of the bank, and it can be logically inferred that the bank was not empowered to compound the offence despite the views of the bank and that is our vision. That is the other I was trying to make this argument that how can a bank official say that?
Ms. Naidu, you have to add anything.
I have to, I'll just recheck on the documents, not just make quality.
Mr. Naik.
I have small submission to make, your lordships.
See, I'll tell you what you have to see. There are two issues. Two judgments here basically relied upon. One is the looking merchant. No, this is what Agarwal. In that case also, what happened is OTS was there with a specific condition that the criminal proceeding will go on. And even then the court went on and quashed it. And the one
Lordship may give me only 2 minutes time.
No, I will give you 2 hours, don't worry, not today. And these are the two judgments, and Naidu also needs some time to go through. I'll fix it after vacation and you address this issue. And Mr. Khanna has done his job. Now you have to address, that's all. You should talk to my husband. You just you give me a timing list, Yes, I will. So sorry. So much can very difficult to
and it should have been present also.
You do one thing. From here, do continuous paging.
I'll do that.
126 onwards. So that it will be easier.
I'll do that.
Okay, I'm noting here. So that I'll do this. Yes. Fix it. Let's do a call anytime.
So did be 23rd October minutes.
October, your lordships, maybe November, your lordship, November first week. I have some difficulty, Lord. November first week. Last week I'm not here. Amit bhai. November first week.